Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And I am not late. I am on time. Tonight is a interesting night because we have, of course, the very, very smooth and supple sounds of me not yelling at all, as I am respecting the house that I am in and the fact that there are tons of other people who can hear me when I drink and get a little too loud. So I'm going to talk to you like a weird DJ with a brain disorder tonight. Hope that's all right with y'all. We're going to pour a little whiskey. We're going to talk about a weirdo by the name of 6ix9ine who makes music that I don't even understand. And then we're going to talk about female genital mutilation in the smoothest, coolest way I can possibly think of. And I hope y'all are ready for that. Nothing more to get you in the mood than the sweet sound of a snipped clitoris, I guess. Is that how this goes? Is that where we are as a society? That we want to go ahead and allow that little snippy snip to take place and talk about it with a calm and quiet demeanor. Not to make light of anything. Hey, what's up, Stephen Birch? See you there in the chat, buddy. Here we go. Here we go. Okay, just as people trickle in, because normally I'm several minutes late, and I'm going to let people compensate for that for my unexpected promptness tonight and punctuality. Uncharacteristic. I will talk about, I have been drinking, this is what I've been drinking all week. I didn't bring a stash of whiskey with me, of course, on vacation here, but I am drinking this Wild Buck American whiskey, which is proudly made, handmade in Florida. It is a 100 proof rye whiskey. I don't know how long it's aged. It does taste delicious, delicious, if I may say so myself. And if you're in Florida, I would strongly recommend it. I don't have anything set up. I just realized I don't have the chat up on stream. Let me do that real quick. This is, if you want to know why I'm actually on time, it's because I clearly haven't prepared the stream at all. All right, let's get the chat pulled up here. I apologize for that. Oh my goodness, what a disaster everything is. Here comes the chat. Doodle doo doo. And then I will get the document pulled up as well, because what's a show without a document? So this is the, where did I put it? Oh, it's on my, one moment here, guys. I downloaded it on my phone earlier, so it's on my Google Drive. Let's see. Let's go ahead and open this bad boy with yeah, I don't care about that. Oh my God. Okay, we're gonna just download a copy of this right to here for now. I've got it all in one place. All right, one moment. Whoa, way too big. Way too big, computer. Seriously. Oh, I hate working with the trackpad, ladies and gentlemen. All right, almost got this pulled up. And nope. This one. There we go. Still a little bit large, isn't it? No, go away. Oh my goodness. Let's see. We've got hold on. Shrink this guy down. There we go. There we go. That's right. Okay. So, what we've learned today is that when I'm not late, it's because I haven't gotten things ready and effectively will be late anyway. Okay. Tracker software PDF Express viewer? No, this is fine. Everything is fine. Leave me alone. Yeah. Edward Pereno. Yes. Yes. We're going to talk about all this stuff. All right, guys. Let's go ahead and get into this document a little bit, if you'll allow me, and we'll go through this. Let me make some caveats and qualifiers here, guys. Caveats and qualifiers. I know nothing about 6ix9ine, the rapper, Tekashi 6ix9ine or whatever, otherwise known as Daniel Hernandez. I have barely heard of him. I've barely heard of him before today, just a little bit. And then, of course, with the news of his indictment being unsealed and having all of these major charges, James, the guy who does my thumbnails, he decided to go ahead and suggest that I cover this case. I think it was actually, he suggested it to me a couple days ago, but I wasn't ready to do it. So I don't know the backstory of this guy. I know his teeth look like some sort of horrific pride parade gone awry in the nightmares of children. I know that he produced some song with Nicki Minaj called Fifi, and I listened to it and I was confused. But that's about all I've got, really. So I may bring in an expert on this, not tonight, because I can't get loud. But I may bring in an expert on this situation by the name of Maxwell Kimball. Some of you may know him in the near future if we keep covering this case. And he can help fill me in on the details. I think that might be a little bit of fun. For now, we're going to just read through the indictment. I will talk about what's going on as best I know. Some of these charges are going to be complex and they're going to be fact specific. These charges were brought by a grand jury. If you don't know what that means, we'll talk about that in just a little bit. But let's get into it here. So this is a grand jury indictment. Crispin Waugh, you unironically listen to 6ix9ine? That is very cool of you, I suppose. If you like him, that's fine. I don't dislike him. I just didn't. I couldn't get into the music. Couldn't get into it. Oh, and a couple things to talk about real quick. This is a live stream. You are welcome to ask all sorts of questions, make comments, participate as you will. You can specifically participate with and interact with me by doing either super chats if you want to give YouTube a cut of the money. If you don't want to give YouTube a cut of the money, and what I always prefer, you can do a justice chat. It is right down in the description. Also, it is up on the top of the top of your screen. The address. You can't click on the video, unfortunately. I wish I could integrate that, but I can't. But it is in the description. It should have a clickable link down there, and you can do a justice chat that will show up over my face, and I will read them, and if there are questions and stuff like that, I happily answer to the best of my ability. Or if you just want to make an off-color joke or an on-color joke or a colorless 2018 racially sensitive joke, you know, again, colorless apparently, because we live in a society, and it is current year. You can do that in the, actually you can kind of say whatever you want in the justice chat. I don't care. If it's too racy for YouTube, I'll mitigate the language a sufficient amount. But yeah, go ahead and drop those in, and I'll be happy to interact with you as well. Otherwise, you can always drop something in the chat without a super chat or a justice chat, but I have no promises, representations, warranties, or otherwise subtle invitations that I will be able to get to them or even see them, because as I'm reading through a document, it sometimes gets hard to follow what's also going on in a chat. With that said, let's dig into this. So this is the United States of America versus Jamel Jones, aka Mel Murda, Kafano Jordan, aka Shotty, Jenzel Butler, aka Ish, Daniel Hernandez, aka Tekashi 6ix9ine. Actually, technically, I think it's 6ix9ine. Fuguan Lovick, aka Fubanga, and Fahim Walter, aka Crippy. They are all the defendants. Why do you keep saying bottom text? Oh, that's the meme thing. Never mind. I apologize. Count 1, racketeering conspiracy. This is against Jones, Jordan, Butler, Hernandez, and Walter. That is everyone but Lovick. At all times relevant to this indictment, Mel Murda, Shotty, Ish, Tekashi 6ix9ine, and Crippy, the defendants and others known and unknown, were members and associates of the 9-Tray Gangsta Bloods. 9-Tray, or the Enterprise. Not the Starship Enterprise, not to be confused with Captain Kirk's voyage. Although I'm sure the 9-Tray Gangsta Bloods did have a continuing mission to seek out new life and new civilizations, and to boldly go where no men have gone before. A criminal organization whose members and associates engaged in, among other activities, acts involving murder, robbery, and narcotics trafficking. 9-Tray operated in and around Manhattan, the Bronx, and Brooklyn, New York. 9-Tray, including its leadership, its membership, and its associates, constituted an enterprise as defined by Title 18, United States Code, Section 1961-4, that is, a group of individuals associated in fact, although not a legal entity. That means they didn't file their paperwork, y'all. Had they filed their paperwork, they simply could have unionized in New York and probably been just fine murdering people. Emily Schewitz says, musicians can sleep with their fans no problem, but lawyers can't? Why? Lawyers can sleep with their fans. They can't sleep with their clients. The difference, of course, being lawyer fans don't typically pay them in the same way that a musician fan would. But the main reason why lawyers are not allowed to sleep with their clients is because lawyers were exchanging legal services in exchange for sexual services, and that was illegal under the prostitution laws. It became it's a conflict of interest, because think about it this way. If the lawyer is billing for sexual services and his services are complete, then he stops receiving sexual services in return. So he is disincentivized from continuing legal services, or he's disincentivized, from resolving legal issues quickly and economically. Otherwise, he's incentivized to drag them out for as long as possible and keep the sexual services going. So, and there were many lawyers who have done this. Many lawyers. There's actually a case of a couple lawyers in Minnesota who are running an amateur pornography ring, which we may be covering very soon. I'm hoping to line up an interview with someone who is tangentially involved in it and talk about their experiences, but I don't know if they want to come on stream and talk to that and talk to the world about that, because it's a little bit interesting and embarrassing. But we'll see. I believe those lawyers were in Minnesota, and they have recently been convicted and do not have a pleasant time coming. And yes, it is the same with money. But, lawmakers see money and sexual services a little bit differently. Maybe they should, maybe they shouldn't. All right, let's get back to it. The enterprise constituted an ongoing organization whose members functioned as a continuing unit for a common purpose of achieving the objectives of the enterprise. At all times relevant to this indictment, the enterprise was engaged in and its activities affected interstate and foreign commerce. Mel Murda, Shoddy, Ish, Tekashi 6ix9ine, and Crippy, the defendants, participated in the operation and management of the enterprise and participated in unlawful and other activity in furtherance of the conduct of the enterprise's affairs. Members and associates of 9ine engaged in a series of violent disputes with rivals of 9ine, including those within 9ine who they deemed disloyal to the enterprise. During these disputes, members and associates of 9ine committed multiple shootings, robberies, and assaults against their rivals and against fellow 9ine members. Todd Rector says, my grandparents were startled when they heard 6ix9ine. I mean to tell you, the only way a lawyer, this is an answer to Killer Clock's question, the only way a lawyer can have a sexual encounter with a client is if they have a pre-existing sexual relationship with that client. And so it's possible that our comic book community is graced by a pre-existing sexual relationship between those two people, and they may carry that on, and as horrific as that may be. All right. Members and associates of 9ine sold heroin, fentanyl, fentanyl. Wait. They already said, fentanyl. That's a different type of fentanyl. MDMA, Dibutalone, and marijuana in and around Manhattan, Brooklyn, and the Bronx, New York. Members and associates of 9ine committed and agreed, attempted, and threatened to commit acts of violence to protect and expand their narcotics business and to protect fellow members and associates of the enterprise. These acts of violence included acts involving murder. I don't know how you involve murder without doing murder. Acts involving robbery and extortion and assault intended either to protect the enterprise's narcotics business, retaliate against members of rival gangs, and who had encroached on the enterprise's narcotics business, to otherwise promote the standing and reputation of 9ine amongst rival gangs, or to promote the standing and reputation of 9ine members amongst other 9ine members. I guess you can't represent unless you be blasting fools. Oh my goodness. Oh my goodness. Purposes of the enterprise. And when we get done with this enterprise section, I will go ahead and talk about what it means to have a grand jury indictment. The purposes of the enterprise included the following. In case you didn't realize from before what they were talking about, we're going to just say it again. Preserving and protecting the power, territory, and profits of the enterprise through acts involving murder, other acts of violence, and threats of violence. Promoting and enhancing the enterprise and the activities of its members and associates. Keeping victims and potential victims in fear of the enterprise and its members and associates through acts and threats of violence. The only violence I know of from 6ix9ine, by the way, is that song Fifi, which committed violence against me earlier today. Providing assistance to members and associates who committed crimes for and on behalf of the gang. Enriching the members and associates of the enterprise through, among other things, robbery and the distribution and sale of narcotics, including heroin, fentanyl, fentanyl, MDMA, dibutalone, and marijuana. Protecting the enterprise and its members and associates from detection and prosecution by law enforcement authorities through acts of intimidation and violence against potential witnesses to crimes committed by members of the enterprise. Means and methods of the enterprise. Among the means and methods employed by the members and associates in conducting and participating in the conduct of the affairs of the enterprise were the following. Members and associates of the enterprise committed, conspired, attempted, and threatened to commit acts of violence, including acts involving murder, to protect and expand the enterprise's criminal operations and against rival gang members. Members and associates of the enterprise used threats of violence and physical violence against other members and associates of the enterprise to enforce and maintain discipline within the enterprise. Members and associates of the enterprise committed, conspired, attempted, and threatened to commit acts of violence, including acts involving murder, robbery, and extortion against rival gang members and other individuals adverse to the enterprise. And if you want to know why lawyers fall asleep reading documents, it's the soothing repetition of acts involving murder, violence, and other things relevant to protecting the enterprise. They overwrite these documents. It's not their fault. They're taught to do this, not in law school, actually, but once they get out of law school. And they're given copy and paste forms for indictments. These are not handcrafted indictments. I can guarantee you that in every federal prosecutor's office, they have access to a template document, which talks about an enterprise involving violence, murder, and protection racketeering. All of that this is probably boilerplate, and they have merely replaced the names at the beginning of the document. If we did a plagiarism, if we ran the plagiarism, the plagiarism website where people upload their papers, and then teachers can upload and check against a series of online papers for plagiarism, this thing would be read for the vast majority of it. If you don't think it's a problem that federal prosecutors are copy and pasting your criminal indictment, then I don't know what to tell you. Members and associates of the enterprise promoted and celebrated the criminal conduct of the enterprise, namely narcotics distribution, acts involving violence, and the use of firearms in music and on social media. Well, I mean, if that's a crime, then pretty much every rapper ever invented is guilty. Members and associates of the enterprise obtained, possessed, and used firearms. Members and associates of the enterprise distributed controlled substances, including heroin, fentanyl, fentanyl, MDMA, dibutylone, goodness gracious, and marijuana. The racketeering conspiracy. From at least in or about 2013 up to and including in or about November 2018 in the Southern District of New York and elsewhere, Mel Murda, Shotty, Ish, Takeshi 6ix9ine, Crippy, the defendants, and others known and unknown being persons employed by and associated with the enterprise, described in paragraphs 1 through 7 of the indictment, namely 9 Trey, which enterprise engaged in and the activities of which affected interstate and foreign commerce knowingly combined, conspired, confederated, and agreed together and with each other to violate the racketeering laws of the United States, to wit, Section 1962C of Title 18, United States Code, that is, to conduct and participate directly and indirectly in the conduct of the affairs of 9 Trey through a pattern of racketeering activity, as that term is defined in Title 18 United States Code Sections 1961(1) and 1961(5), consisting of multiple acts involving murder, chargeable under the following provisions of state law: New York Penal Law Sections 125.25, murder; 110.00, attempted murder; 105.15, conspiracy to commit murder; and 20.00, aiding and abetting murder. Multiple acts involving robbery, chargeable under the following provisions of state law: New York Penal Law Sections 160, a whole bunch of 160, 105, 110, and 20. Multiple acts indictable under Title 18 U.S. Code Section 1951 related to the interference with commerce, robbery, or extortion, and multiple offenses involving the distribution of controlled substances, including heroin, fentanyl, fentanyl, MDMA, dibutylone, and marijuana, in violation of laws of the United States, namely Title 21 U.S. Code sections, a whole bunch of those. It was a part of the conspiracy that each defendant agreed that a conspirator would commit at least 2 acts of racketeering activity in the conduct of the affairs of the enterprise. All right, that's count 1. Before I read count 2, let me briefly talk about grand jury indictments. So a grand jury indictment is how you do a federal high crimes charge. For a felony charge, you have to be charged by a grand jury. A grand jury is a group of jurors within a particular district. They are then presented with evidence by a prosecutor. They are not presented with a defense. The defendant is not allowed to be present. None of that happens. It is all the prosecutor permitted to present any evidence suitable to bring probable cause, suitable to find, I should say, probable cause to bring the charges. That means that they can use evidence that is otherwise inadmissible in court. They can bring evidence from an illegal search to a grand jury. They can bring witness testimony that they know to be false to a grand jury. They do not have to provide exculpatory or evidence that would otherwise make a party look innocent. They are not allowed to counter argument. They can examine witnesses, and they're not. Those witnesses are not cross-examined by a defense attorney, and they are allowed to lead those witnesses to certain answers. So the federal rules of evidence are out the window in a grand jury indictment. A grand jury indictment does not mean that someone can be found guilty. It means there are probable causes based on the information that they have to bring charges. Throwing out evidence and all of that happens at an evidentiary hearing at a later date. So, take everything in a grand jury indictment with a bit of a grain of salt, because much of the evidence that's gathered could be thrown out at some point. Testimony from people inside a grand jury could change. The only time that grand juries really matter are when they refuse to bring charges, such as in the shooting death of Mike Brown by Officer Darren Wilson. When all of the people who were saying hands up, don't shoot, prior to the grand jury were called in to do their grand jury testimony and were brought under oath, and they all recanted that statement. Every single one of them, except for Mike Brown's friend. But all of the witnesses who said Mike Brown's hands were up and he was saying don't shoot changed their story at the grand jury hearing, and that grand jury did not decide to bring charges. So just know that grand jury charges are charges, similar to what is brought by a prosecutor without a grand jury, and that those are accusations. They are far, far, far from being proven. Zephael, they cannot knowingly bring false evidence. They cannot knowingly present something as fact which they know to be not factual. However, they can't do that in real trials, and they do anyway. So if you think when there is a grand jury and there is no one there to say objection that they're not doing it, you can think that if you choose. Think that if you choose. All right. Let's move on to count 2, firearms offense, racketeering, conspiracy. The grand jury further charges. From at least in or about 2013 up to and including in or about November 2018 in the Southern District of New York and elsewhere, except in connection with the robbery on or about April 3rd, 2018 in the vicinity of West 40th Street and 8th Avenue in Manhattan, New York, as charged in counts 3 through 5 of this indictment. Mel Murda, Shadi, Ish, Tekashi 6ix9ine, and Crippy, the defendants, during and in relation to a crime of violence for which they may be prosecuted in a court of the United States, namely the racketeering conspiracy charge in count 1 of this indictment, knowingly did use and carry firearms, and in furtherance of such crimes did possess firearms, and did aid and abet the use, carrying, and possession of firearms, some of which were brandished and discharged. So there is a separate criminal charge at the federal level. When you are brought before a court and you used a firearm in the commission of any other crime, you get a separate crime, and it increases the level of sentence you could receive. Zephael says, whiskey for winter, gin for summer. Drink, drink. Here, here, buddy. But I'll choose whiskey and gin for both winter and summer. Count 3, violent crime in aid of racketeering. Now, if you notice, these counts are all defeatable if the first count of racketeering is defeated. And bringing a RICO action, a racketeering charge, is a very, very difficult thing for the state to prosecute. RICO charges are specific. They are hard to do, although they are specifically created to stop gangs from distributing illegal substances. So this might fall right into RICO. That's the purpose of the law. It is why all of this exists. And assuming the statements in the indictment are true, it doesn't look good for our heroes. At all times relevant to this indictment, 9 Trey, as described in paragraphs 1 through 7 of count 1 of this indictment, which are repeated and incorporated by reference as though fully set forth herein, including its leadership, members, and associates, constituted an enterprise as that term is defined in Title 18 U.S.C. Section 1959b2. That is, an association, in fact, of individuals engaged in and the activities of which affected interstate and foreign commerce. And yes, the selling of illegal substances does interfere with interstate and foreign commerce, because if you're not buying your illegal substances from, or if you are buying your illegal substances from 9 Trey, you're not stealing them from clinics or hospitals, and you're not buying them from some other gang. So, just so you know, if there is activity involving commerce, 9 times out of 10, Congress will determine that that activity interferes with and affects interstate and foreign commerce, which we will be discussing a little bit later when we talk about female genital mutilation, because that's a very interesting ruling. All right. The enterprise constituted an ongoing organization whose members functioned as a continuing unit for a common purpose of achieving the objectives of the enterprise. At all times relevant to this indictment, 9 Trey, through its members and associates, engaged in racketeering activity, as that term is defined in Title 18 U.S.C. Sections 1961 and 1959, namely acts involving murder and robbery in violation of New York penal law, robbery and extortion in violation of Title 9 U.S.C. Section 19 or Title 18, U.S.C. Section 1951, and narcotics trafficking in violation of Title 21 U.S.C. Sections 812, 841, and 846. On or about April 3rd, 2018, in the Southern District of New York and elsewhere, Shoddy, Ish, Tekashi 6ix9ine, and Crippy, the defendants and others known and unknown, as consideration for the receipt of and as consideration for a promise and agreement to pay a thing of pecuniary value from 9 Trey. Pecuniary means monetary value. And for the purpose of gaining entrance to and maintaining an increased position in 9 Trey. Notice the typo. Good job, federal government, not proofreading your document. Or I guess it could be entrance to and maintaining and increasing position. I would read it to maintaining an increasing position, but that's me. Who knows what they're after? In 9 an enterprise engaged in racketeering activity as described above, knowingly assaulted individuals with a dangerous weapon, and aided and abetted the same, to wit, Jordan, Butler, Hernandez, Walter, and others participated in a gunpoint robbery of rivals of 9 in the vicinity of West 40th Street and 8th Avenue in Manhattan, New York. There you go, count 4, violent crime in aid of racketeering. So again, so far every count is predicated on the racketeering charges. If any part of the racketeering charges are disproven, including the existence of an enterprise in fact under the definition, then all of the charges so far will have to be dropped. At all times relevant to this indictment, 9 as described in paragraphs 1 through 7, is an enterprise, and it's fully incorporated herein. Let's move on. At all times relevant to this indictment, 9 through its members and associates engaged in racketeering activity. Let's move on from that because this is the same wording. On or about April 3rd, 2018, in the Southern District of New York and elsewhere, Shoddy, Ish, Tekashi 6ix9ine, and Crippy, the defendants and others, known and unknown, as consideration for the receipt of and as consideration for a promise and agreement to pay a thing of pecuniary value from 9 and for the purpose of gaining entrance to and maintaining and increasing position in 9 an enterprise engaged in a racketeering activity as described above, conspired to commit assault with a dangerous weapon. To wit, Jordan, Butler, Hernandez, Walter, and others agreed to rob at gunpoint rivals of 9 So not only did they rob them, they planned it. They agreed to do that. That's a conspiracy charge. Count 5, firearms offense. On or about April 3rd, in the Southern District of New York, Shoddy, Ish, Tekashi 6ix9ine, and Crippy, the defendants, during and in relation to a crime of violence for which they may be prosecuted in a court of the United States, namely, the assault with a dangerous weapon and conspiracy to do the same, as charged in counts 3 and 4 of this indictment, knowingly did use and carry firearms, and in furtherance of such crime did possess firearms, and did aid and abet the use, carrying, and possession of firearms, some of which were brandished. Count 6, violent crime in aid of racketeering. So we have the enterprise being defined yet again. Then, at all times relevant to this indictment, Fuguan Lovick, don't forget about Fuguan, Fu Banga, the defendant, and others known and unknown were members and associates of 9 Oh my, excuse me. And at all times relevant to this indictment, 9 through its members and associates engaged in racketeering activity, blah, blah, blah. On or about April 21st, 2018, in the Southern District of New York and elsewhere, Fu Banga, the defendant, as consideration for the receipt of and consideration for a promise and agreement to pay a thing of pecuniary value from 9 and for the purposes of gaining entrance to and maintaining an increasing position in 9 an enterprise engaged in racketeering activity as described above, knowingly assaulted individuals with a dangerous weapon and aided and abetted the same. To wit, Lovick fired a gunshot at rivals of 9 upon encountering them at the Barclays Center in Brooklyn, New York, in violation of New York penal law. Count 7, firearms offense. On or about April 21st. Notice this is the same thing. This is the same thing. However, this is a firearms offense, not a assault with a deadly weapon offense. Violent crime in aid of racketeering offense. There's also a firearms charge. Now here's the violent crime in aid of racketeering. This again is back to Jordan, Butler, Hernandez, and Walter. Okay, so we're not going to read the definitions again. Okay, so this time they conspired to commit murder and assault with a dangerous weapon. To wit, Jordan, Butler, Hernandez, Walter, and others agreed to shoot an individual who had shown disrespect to members of 9 and as a result of this agreement, an innocent bystander was shot in the vicinity of Fulton Street and Utica Avenue in Brooklyn, New York, in violation of New York penal law, sections 120.05, 120.10, and 125.25. So they attempted to shoot a gangster of some sort and shot an innocent bystander. Not good. Not a good thing to have. Judges, juries do not like when innocent people are shot in gang violence. They don't like when gang members are shot either, but they really dislike the innocent people getting tagged. Super Channel Awesome Time. Enterprise is a legal term. It is a legal term defined under the RICO Act, racketeering. Forfeiture allegations as to count 1. So we'll see what the government went ahead and seized from 6ix9ine. Hopefully they seized Nicki Minaj. Scotius Maximus I. Does assault with a deadly weapon mean someone was shot or just shot at or both? Assault with a deadly weapon means that a weapon was used in the commission of an assault. So technically, if you pulled out a gun and you hit someone with it, you have committed assault with a deadly weapon. That's how it goes. Shooting at someone is assault with a deadly weapon as well. Assault does not require contact to take place in most state laws. In common law, assault specifically excludes any sort of contact, but criminal law is defined by state law, and assault would typically be defined under criminal law as either it would be involved as assaulting someone, as committing an act of violence against them. So, please say the word starship in front of every instance of the word enterprise. All right. As a result of committing the offense alleged in count 1 of this indictment, Mel Murda, Shoddy, Ish, Tekashi 6ix9ine, and Crippy, the defendants shall forfeit to the United States, pursuant to Title 18 U.S.C. Section 1963, any and all interests the defendants acquired or maintained in violation of Title 18 U.S.C. Section 1962, any and all interests in securities of, claims against, and property or contractual rights of any kind, affording a source of influence over the enterprise named and described herein, which the defendants established, operated, controlled, conducted, and participated in the conduct of, in violation of Title 18 U.S.C. Section 1962, and any and all property constituting and derived from proceeds obtained directly and indirectly from the racketeering activity alleged in count 1 of this indictment, including but not limited to a sum of money in United States currency representing the amount of proceeds traceable to the commission of said offenses that the defendants personally obtained. Now, let's talk about this. This is right here. This is the killer. Do you notice what they said earlier in the indictment? That they bragged about doing certain activities in music and other things. That means that they're going to claim, as the United States government, that the proceeds from 6ix9ine's music sales would be indirectly obtained from the racketeering activity alleged in count 1 of this indictment. Go ahead and just hand over all assets unless you can trace them otherwise. So perhaps you can show receipts of gifts. Perhaps you can show that some things predated the racketeering activity. Good luck. Good luck. Substitute assets provision. If any of the property described above as subject to forfeiture as a result of any act or omission of the above-named defendants cannot be located upon the exercise of due diligence, has been transferred or sold to or deposited with a third person, has been placed beyond the jurisdiction of the court, has been substantially diminished in value, or has been commingled with other property which cannot be subdivided without difficulty, it is the intent of the United States pursuant to Title 18 U.S. Code Section 1963M, Title 21 United States Code Section 853P, and Title 28 United States Code Section 2461C to seek forfeiture of any other property of the defendants up to the value of the above forfeitable property. They gonna lose everything even if they're not guilty. And then they can try and win it back. I hope they don't have stacks of cash, because those stacks of cash tend to vanish when the feds get their hands on them. So, that is the indictment against 6ix9ine. He is up a certain kind of creek. I don't know how else to put it. He's got a long fight ahead of him. It'll be very interesting to see how it develops. I'm not familiar with 6ix9ine's activities outside of the music he has created, of which I am only barely familiar. That's why I may bring on an expert to talk about this at some point in the very near future. Zephael, no, they don't lose their street cred. That's right. Their street cred will only increase from this activity. So, real quick, Boz says, have a drink on me. Good work as always. Thank you, Boz. I really appreciate it, buddy. Yes, Squisher 420. I know he has more charges. Those would be the state charges against him in New York. And maybe that's when I'll bring on the expert. We'll see. We'll see. If you guys are interested in 6ix9ine, go ahead and let me know in the comments if you want some follow-up videos on him. Perhaps we can talk about more. I will monitor the federal case and see what else becomes of it. There's not, you know, there's a waiting game involved in all of this stuff. So it will be interesting to see what they claim as defenses. They are certainly, at this point, innocent until proven guilty in a court of law. Opus Day says, Happy Thanksgiving, Rackets. Hail. Hail back to you, sir. Happy Thanksgiving to you as well. It is officially Thanksgiving here in the Eastern Time Zone. And it is my favorite holiday. I hope you all have someone to share it with. We're about to move on to a certain other family activity that is cultural. Thanksgiving, of course, is an American cultural tradition that many of you are familiar with. Thanksgiving is based on a little bit of a false story, but not the worst false story, about a group of early American settlers who teamed up with Indians to rid the world of the pesky turkey population, and the only way they could think of to do it, by eating them. Now, of course, turkeys are mass-produced and have been bred in numbers far exceeding any sort of natural capacity, and then they are ritually slaughtered and sent to all of us for delicious, delicious food. And I strongly recommend partaking in as many turkey dinners as you can. Now, let's talk about another favored cultural pastime. This one is not very much an American tradition, although some people are trying to make it so. So we're going to talk about that as well. I don't know if you guys have heard of this particular cultural tradition celebrated by groups of people out there all over the world. Actually, one of the largest people groups in the world, if we break them down into categories, comprising somewhere around 1/6 of the population. Now, I'm not saying that all 1/6 of the world population participates in this particular cultural tradition. However, it is a tradition that specifically derives from this people group and is primarily practiced by this people group. And of course, we're talking about the time-honored tradition of female genital mutilation. Some people would consider female genital mutilation to be a barbaric practice, but like all barbaric things, we have found ways to sanitize and make it safe and acceptable for all people. And if you detect a hint of irony in my voice, I assure you that is merely a figment of your imagination. Now, female genital mutilation was recently made illegal in the United States. 18 U.S.C. 116. Why don't I go ahead and pull that up real quick, and we'll see what the good old United States says about female genital mutilation. Now, I'm not going to pull this up on screen because it's just a pain, and I am terrible with technology and with a trackpad and not being at home and only having one screen tonight. It's a little bit of a chore, so bear with me as I just read to you. The statute against female genital mutilation. So this is 18 U.S.C. section 116. Except as provided in subsection B, whoever knowingly circumcises, excises, or infibulates the whole or any part of the labia majora or labia minora or clitoris of another person who has not attained the age of 18 years shall be fined under this title or imprisoned not more than 5 years or both. Next, a surgical, this is subsection B, the except as provided in. A surgical operation is not a violation of this section if the operation is 1. Necessary to the health of the person on whom it is performed and is performed by a person licensed in the place of its performance as a medical practitioner, or 2. Performed on a person in labor or who has just given birth and is performed for medical purposes connected with that labor or birth by a person licensed in the place it is performed as a medical practitioner, midwife, or person in training to become such a practitioner or midwife. Subsection C is in applying subsection B1, no account shall be taken of the effect on the person on whom the operation is to be performed of any belief on the part of that person or any other person that the operation is required as a matter of custom or ritual. So, when they say necessary to the health of the person in subsection B1, they do not mean the spiritual or religious health of a person, only the physical health of a person, and the person's religious beliefs are not considered. It is equally applied at a facial level. Whoever knowingly, subsection D, whoever knowingly transports from the United States and its territories a person in foreign commerce for the purpose of conduct with regard to that person, that would be a violation of subsection A if the conduct occurred within the United States, or attempts to do so, shall be fined under this title or imprisoned not more than 5 years or both. So if you try to exercise your First Amendment religious rights to go ahead and chop the clitoris off of your child, and you can't do it in the U.S., you decide to take them to, I don't know, where might they do this? Iran, Saudi Arabia, somewhere like that. If you decide to go ahead and do that, as would normally be your legal right, you are still in violation of this chapter, in an egregious affront to your religious freedoms. So you can't take your child or anyone else's child out of the country for female circumcision or female genital mutilation. Pick your choice of wording. Keck7Go asks, do you think that the justice system that leaves people with heavy debt when defending themselves against people who are clearly wrong, like lawsuits and evicting non-paying tenants, creates a breeding ground for future serial killers and nihilists? Oddly enough, I don't know of any serial killers who have gone on to murder a bunch of people due to a lawsuit, although if you do know of one, please go ahead and send their information to me, and we will talk about that in a heartbeat on this show. Nihilists, absolutely. Lots of people have various opinions about the legal system, but almost everyone who's been through the legal system has the same opinion that it needs to go. All right. All right, let's read through the rest of this complaint for the female genital mutilation. This is 11 pages. I'm going to try and breeze through it as fast as possible, and then we're going to talk about the judge's opinion. So we actually have 2 documents on the female genital mutilation, but I wanted to make sure for posterity we go ahead and understand what these people are charged with, so that we understand the crimes that have been dismissed. This case has been dismissed by a federal judge, and he has ruled that the statute we've just read, U.S. Code, 18 U.S. Code Section 116, is unconstitutional under the 10th Amendment. That's right. That's the states' rights. That's what caused the Civil War the first time. And of all things, think about this, ladies and gentlemen. Of all things on earth that are states' rights issues, a federal judge decided to stand up for this one. Just remember that. This one. Not marijuana, not immigration, not firearms, not gay marriage, not, what else is there? Transgender bathrooms, those aren't state issues. None of that stuff is a state issue, but female genital mutilation, whoa, whoa, whoa. Let's not be too hasty in federally regulating that. Keck7Go says, then I learned if a beta male mandrill wins a fight, it physically morphs into an alpha male over time, gaining facial coloration, bigger testicles, and the ability to breed. That's true of real men as well. All right, let's go ahead and talk about this. Affidavit in support of the complaint. The undersigned Kevin J. Swanson, hereinafter referred to as the affiant, first being duly sworn and conditioned, hereby deposes and states the following. I am a special agent with the Federal Bureau of Investigation assigned to the Detroit field office since July 2010. As part of my duties, I investigate crimes related to healthcare fraud, prescription drug diversion, public corruption, and international human rights violations. I've received specialized training on the subjects of healthcare fraud, money laundering, telephone analysis, and white-collar crime from the FBI. I have also met with domestic and foreign law enforcement agents and officers in order to investigate international corruption and human rights violations. I am also working with and consulting with Special Agent Lisa Keith of Homeland Security Investigations, who has extensive training and experience in the investigation of child exploitation crimes. This affidavit is made in support of a criminal complaint and arrest warrant for Jumana Nagarwala for violating 18 U.S.C. 116, female genital mutilation, 18 U.S.C. 2423 transport with intent to engage in criminal sexual activity and conspiracy, and 18 U.S.C. 1001, making a false statement to a federal agent. Jumana Nagarwala is a traditional Central European name, from what I understand. So please make no judgments about the name Jagar Nagarwala. Jumana Nagarwala. Sorry to offend the Central Europeans out there who traditionally possess the Nagarwala surname. It is time-honored to Central Europe. And we have no idea what religion is involved with Mr. Nagarwala. The affidavit is submitted for the limited purpose of securing a criminal complaint and arrest warrant. Therefore, this affidavit does not contain every fact that I have learned during the course of the investigation, I have only set forth the facts necessary to establish probable cause to believe that Nagarwala violated the statutes identified above. The information contained in this affidavit is based upon my personal knowledge, training, and experience, as well as the combined training and experience of other law enforcement officers and agents with whom I have had discussions. And Hessian, I would never forget Justice Chats, my friend. Those last two that I read were Justice Chats, and I'm about to read yours. Hessian. Why would a Jewish judge protect female genital mutilation? Waiting for Raket's explanation on the First Amendment regarding this and how performing irreversible surgical operation on a minor does not violate their religious freedom and stuff. Well, now. I think I know where you're going with that, and I do plan on talking about that candidly as we get later in the discussion. Title 18 U.S.C. Section 116 prohibits knowingly circumcising, excising, or infibulating the whole or part or any part of the labia majora or labia minora or clitoris, or another person who has not attained, or of another person who has not attained the age of 18 years. So you can you can engage in your own genital mutilation prior to 18 years. Good job. Title 18 U.S.C. Section 2423 makes it a crime to knowingly transport a minor in interstate or foreign commerce with the intent that the child engages in any sexual activity for which a person can be charged with a criminal offense. Section 2423E states that whoever conspires to violate subsection A shall be punishable in the same manner as a completed violation of that subsection. Federal law defines sexual act as touching of the genitalia with the intent to abuse, humiliate, harass, or degrade. 18 U.S.C. 2246. Nagarwala's removal of clitoral skin from 7-year-old minor females is a sexual activity that violates both federal and state law. Female genital mutilation. According to the World Health Organization, WHO, FGM is an internationally recognized violation of human rights of girls and women. FGM is classified into 4 major types, which vary based on the severity of the procedure. The following information regarding these types of FGM is published by the World Health Organization. Type 1, often referred to as clitoridectomy. This is the partial or total removal of the clitoris, a small, sensitive, and erectile part of the female genitals, and in very rare cases, only of the prepuce. I don't know if I'm pronouncing that right. The fold of skin surrounding the clitoris. Type 2, often referred to as excision. This is the partial or total removal of the clitoris and the labia minora, the inner folds of the vulva, with or without excision of the labia majora, the outer folds of skin of the vulva. Type 3, often referred to as infibulation. This is the narrowing of the vaginal opening through the creation of a covering seal. The seal is formed by cutting and repositioning the labia minora or labia majora, sometimes through stitching, with or without the removal of the clitoris. And there's a footnote that I haven't gotten to, but I will get to it once we read Type 4. Type 4, this includes all other harmful procedures to the female genitalia for non-medical purposes, e.g. pricking, piercing, incising, scraping, and cauterizing the genital area. Just in case we were confused about cauterizing the genital area. The footnote says one purpose of female genital mutilation is to curb the sexuality of girls and women by making sex painful. As a result, there is probable cause to believe that the intent is to abuse, humiliate, harass, or degrade. Therefore, FGM qualifies as a sexual act for which any person can be charged with a criminal offense. Now that we have laid out the 4 types of female genital mutilation, I want to address what I believe Hessian's comment is directed towards, and where I think many people of a certain political spectrum, a rising political spectrum, and that's not to make, this is, I'm not making that perspective, I'm not making light of the perspective, okay, before anyone jumps on me for this. There is a growing, should I make an erection joke? No, there is a growing group of people who are opposed to what they would consider male genital mutilation or traditionally male circumcision, and are, in my humble opinion, using the issue of female genital mutilation, oftentimes referred to as female circumcision, to conflate the two procedures. What I will caution them on in this argument, hear me out before you get frustrated, because I know I've heard many of these arguments, okay? I will caution you on, in conflating these two issues, the purposes of the procedures and the effects thereof are vastly different between male and female circumcision. That said, I think there is a valid point to the idea of looking at male circumcision as a violation of a male child's rights. I'm not 100% there yet. I'm not 100% there personally yet. However, I definitely see the argument. I see the argument and the logic behind it. But I want to caution you, when you make your argument and you conflate it with something that is a distinctly different issue with distinctly different results. One, making sexual activity painful for the recipient of female circumcision versus male circumcision. That alone makes this a different question. The ages involved are often vastly different as well. So I'm cautioning you merely on the semantic points of the argument, that if you conflate the two, you will be slower to convert people, I believe, to your position on the argument, because they are distinctly different and produce drastically different results. That said, there is a discussion to be had about male circumcision and its usefulness in the world. I think many, many people have been told through various arguments by medical professionals for years that there are health benefits to male circumcision, which I believe those claims may be dubious. I'm not willing to state that they are outright false. I'm saying they're dubious. They require further investigation outside of a bias towards circumcision. So let me go ahead and leave it there. Let me say that I am open to discussing the topic in another video. This video, I want to focus on the female genital mutilation that is going on, because, as I said, they are different issues. One is illegal in the United States, one is not, and if we get wrapped up in trying to make this issue about another issue, then we'll never move past it. So I hope that answers your question on my position, and where I think the law is on that. It is interesting. It is interesting that a Jewish judge defended this, and I have no idea if he defended it on religious grounds or if it was some other purpose, although I do find the 10th Amendment dismissal to be strange, but I haven't read the entire opinion yet, so we'll get to that, and maybe we'll get some insight from his own words. There's a couple chats, and then we will move on. Jason Ben-Ames says, say clitoris again, quieter. Clitoris. Is that for you? I hope that's for you. That was helpful for you, my friend. Kex7Go says, my new favorite line from r/legal advice, TLDR, sold dildos to 2 gay cops, now looking at a misdemeanor, trying to guess the case and state. Or try to guess the case and state. If you are correct, I will send you alcohol. Let's see. sold dildos to 2 gay cops, now looking at a misdemeanor. I'm going to say it was Florida. Florida was the state. And I'm going to guess that the crime is something to the effect of the unlicensed distribution of sexual paraphernalia. Am I right, Keck? Please let me know. Ryan English says, there's an argument to be had, but damned if people on both sides don't get triggered real quick whenever one attempts to have it. And that is true. That is true. People are highly passionate about this issue. And I think there's a heavy dose of propaganda coming from both sides on it. And I think that plays into the triggering and the quick reaction and the quick escalation that's going on. But like I said, this is a channel where we do tackle some heavy subjects, and maybe that would be an interesting debate to have. Maybe that would be an interesting debate to have sometime. Someone who is ardently for and someone who is ardently opposed to male circumcision. But again, not today. Not today. All right. So back to the document. Keck, let me know if I was correct on that thing. Oh wait, there's another chat. We can expand on the subject later if you like, Giggity. You should also lower the SL threshold so I can throw more at you. What's the SL threshold? I don't know what the SL threshold is. All right. Based on your affiant, Streamlabs. The Streamlabs threshold, $2, I think, is like about as low as it goes. I guess I could lower it to $1 at some point, but we'll see about that. We'll see about that. All right. Based on your affiant's experience in this investigation, some members of a particular religious and cultural community, hereafter the community, come on. Some members of a particular religious and cultural community. Let's see. Are known to practice female genital mutilation on young girls in the community as part of their religious and cultural practice. Based on your affiant's experience, listen to the tiptoeing in this indictment. In this investigation, when female genital mutilation is performed in the community, varying amounts of a girl's clitoris or clitoral hood or prepuce are removed by the person who is performing the cutting. According to some members of the community who have spoken out against the practice, the purpose of this cutting is to suppress female sexuality in an attempt to reduce sexual pleasure and promiscuity. Again, different intents. An increasing number of females in the community worldwide have begun to speak publicly about female genital mutilation and the effects it has had on them and their families. Many describe pain during the procedure and a variety of effects on their physical and mental health later in life. Probable cause. We'll go back to probable cause in just a moment. Keck7Go said, today, I was at work, a 7-Eleven type shop, but with pipes and cigarettes and such, and 2 guys who were cops came in and bought about $80 worth of toys. The store is within 1,000 feet of a residential area, and apparently that is not allowed in California. Oh, I figured it was a Florida man selling dildos on the side of the road, because that would be, they're selling dildos in front of a school or something like that. All right. All right. Probable cause. FBI and Homeland Security investigations received information that Nagarwala was performing female genital mutilation in the Eastern District of Michigan. The information indicated that Nagarwala performed female genital mutilation on girls who were about 7 years old at the time at a medical clinic in Livonia, Michigan. RZEQDW, I see your chat, but I'm not going to read it. I'll read the ree. Like I said, I don't, guys, I tried to head this off. This case that we're reading is about female genital mutilation, and I'm happy to host a discussion about circumcision, or as it is referred to now, male genital mutilation, in the very near future. But I would like a proper forum for that to happen, and I think I would love to host it as a debate between some people who are for or against it. So again, let's move on from that and not make this one about the boys. This one can be, we can give this one to the girls, right? The ladies deserve a little love and a little less chop chop. Your affiant and other agents determined that Nagarwala is employed as an emergency room physician at a hospital in Detroit. Nagarwala does not work at the medical clinic, and there is no record of her. Oh, her. She's a female. Billing for medical procedures there. Nagarwala is a member of the community. I guess the patriarch in me assumed that the doctor was a man. In February 2017, your affiant and other agents served an 18 U.S.C. 2703D court order on Sprint PCS, requesting call detail records for Nagarwala's phone. On February 27th, 2017, Sprint PCS provided the requested records to the FBI. Review of Nagarwala's telephone calls identified a series of phone communications between Nagarwala's phone and a Minnesota telephone number. Now, I have no idea who in Minnesota would be calling anyone in Detroit. Your affiant and other agents determined through database and social media checks that the Minnesota number was associated with a Minnesota family that had a daughter who had just turned 7 years old, Minnesota Victim 1, or MNV1. The Minnesota family was part of the community in Minnesota. Footnote 2, the name and address of the medical clinic is known to your affiant. On March 3rd, 2017, your affiant and other agents requested call detail records for the Minnesota telephone number. Review of these records revealed that on February 3rd, 2017, the phone assigned to the Minnesota number traveled from Minnesota to Michigan. On the evening of February 3rd, 2017, the Minnesota number contacted a tower in Farmington Hills, Michigan, near multiple hotels. On February 4th, 2017, the phone returned to Minnesota. Your affiant and other agents requested records from hotels in Farmington Hills and determined that Minnesota Victim 1, Minnesota Victim 2, and their parents stayed at a hotel in Farmington Hills on the evening of February 3rd, 2017. Records show that a parent of Minnesota Victim 2 rented 2 hotel rooms at Hotel 1 on February 3rd. Surveillance video obtained from Hotel 1 shows 2 adult women and 2 minor girls checking into Hotel 1. Your affiant believes these people were Minnesota Victim 1, Minnesota Victim 2, and their mothers. On April 10th, 2017, Minnesota Victim 1 was interviewed by a child forensic interviewer employed by the FBI. Minnesota Victim 1 is 7 years old. Minnesota Victim 1 stated that she was brought to Detroit, Michigan with Minnesota Victim 2 for a special girls' trip. After they arrived at the hotel, Minnesota Victim 1 advised that she and Minnesota Victim 2 had to go to the doctor because our tummies hurt. While at the doctor's office, a procedure to get the germs out of her was performed. Minnesota Victim 1 identified an unmarked photograph of Nagarwala and said that she was a person who performed the procedure. Minnesota Victim 1 said she took off her pants and underwear and laid on an examining table with her knees near her chest and her legs spread apart. This is exactly how tummies are treated within my community. I don't know about yours. Minnesota Victim 1 said that Nagarwala pinched her on the place where she goes pee and that she was given a pad to wear in her underwear. Minnesota Victim 1 said that she was told not to talk about the procedure. On April 11, 2017, a medical doctor in Minnesota performed a complete medical exam of Minnesota victim 1. Pursuant to a search warrant, your affiant has spoken with the medical doctor who performed the exam, and the doctor's preliminary findings are that Minnesota victim 1's genitals are not normal in appearance. Minnesota victim 1's labia minora has been altered or removed, and her clitoral hood is also abnormal in appearance. Finally, the doctor observed some scar tissue and small healing lacerations. On April 10th, Minnesota victim 2 was interviewed by a child forensic interviewer employed by the FBI. Victim 2 is also 7 years old. Victim 2 said that she came to Detroit with victim 1 and that she went to a doctor's office. She identified a photograph of Nagarwala as the doctor who she saw in Detroit. Victim 2 said it in the examination room, Nagarwala took off her pants and underwear and put her on the table. She said that she got a shot and that it hurt really badly and she screamed. Victim 2 said the shot was on her upper right thigh. Victim 2 drew a picture of the room and she drew an X to indicate blood on the examining table. Victim 2 said her parents told her that the procedure is a secret and that she is not supposed to talk about it. Victim 2 said that after the procedure she could barely walk and that she felt pain all the way down to her ankle. Victim 2 said Nagarwala told her that she was fine. Victim 2 said that she left one of her winter gloves in the medical office. Hopefully the office will return that winter glove. Winter is very serious in Minnesota. On April 10th, 2017, a search warrant was executed at the medical clinic. During the search, agents found a child's winter glove at the medical clinic. The glove had victim 2's first name written on it. Well, thankfully, she'll get it back after the trial. On April 11th, 2017, a medical doctor in Minnesota performed a complete examination of victim 2 pursuant to a search warrant. Your affiant has spoken with the medical doctor who performed the exam, and the doctor's preliminary findings are that victim 2's clitoral hood has a small incision, and there is a small tear to her labia minora. On April 10th, a local Minnesota Child Protective Services personnel and a federal agent interviewed the parents of victim 2. Parents of victim 2 confirmed that they took victim 2 to Detroit to see Nagarwala for a cleansing of extra skin. This investigation has identified other children who may have been victimized by Nagarwala between 2005 and 2007, including children in Michigan. On April 10th, 2017, local Child Protective Services personnel and child forensic interviewers employed by the FBI and Homeland Security investigations interviewed several minor girls in Michigan about female genital mutilation. In these interviews, multiple minor girls informed Child Protective Services and forensic interviewers that procedures had been performed on their genitals by Nagarwala. Parents of some of the Michigan children interviewed on April 10th were also interviewed by law enforcement on April 10th. Two parents stated that Nagarwala had performed procedures on their daughter's genitals, while others denied knowledge of the procedure or said it did not happen. On April 10th, Nagarwala voluntarily agreed to be interviewed by an HSI, that's Homeland Security Investigation Special Agent, and Michigan Child Protective Services personnel. During the interview, Nagarwala was told that the HSI agent was a federal officer and that making false statements to a federal officer was a criminal offense. Nagarwala then stated that she is aware that FGM is illegal in the United States. She had no knowledge of FGM being performed by anyone in her community, that she had never performed FGM on any minor children, that she was not involved in any FGM procedures. Conclusion. Based on the aforementioned factual information, there is probable cause to believe that Nagarwala has violated 18 U.S.C. Section 116. Footnote 3 says some of the minor children who were interviewed made no statements about FGM procedures or Nagarwala. 18 U.S.C. 2423 AE, transportation with intent to engage in criminal sexual activity and conspiracy, and 18 U.S.C. Section 1001, making a false statement to a federal agent. So there is your indictment. That is what we are talking about. And again, a very, very serious issue that is going on in a particular community. Just a particular community, though. We don't actually know which one it is, but it's a particular one. Should I quickly, let's look up Nagarwala, huh? Here we go. We're going to go ahead and I'll pull up her picture on screen for you just a moment here. We'll just do this real quick. Excuse me while I add a let's just add a window here. Window capture. So here she is. This is Dr. Nagarwala right there. So just so you know, the smiling face of the person who is cutting off parts of little girls' genitalia while they're 7 years old, encouraging them to lie about it, lying to federal investigators about it, and doing so in knowing violation of existing U.S. law. Again, there's some real interesting you know, details. So I just wanted to give you a picture of the person. Now I'm going to promptly remove it from existence because it doesn't need to go. All right. Here we have the opinion. Now the opinion is 28 pages. All right. So you'll have to bear with me for a little bit. I appreciate, of course, all of the time that you do spend with me, and I very much enjoy bringing you interesting and often controversial content, and I hope that you enjoy these streams as much as you enjoy various other streams about other topics. But we gotta intersperse the important with the fun, right? Right? So John Cook, I didn't say allegedly because she admitted to it. Well, not really. I didn't say allegedly because this judge says it's no longer illegal. Lazarian444 says, I kind of understand why we need to drink now. Yes, and I apologize. I really don't like bringing up the reasons for drinking. But so we've got to confront reality, right? Can't all just be fun and games on Twitter as much as I'd love to. Let's see. Keck7Go says, what is the worst crime? Mutilating little children or lying to a federal investigator? Well, I know the government's position. But no, the genital mutilation is a 5-year sentence, and I think lying to an investigator is slightly less. Slightly less. All right. So opinion and order. Granting defendant's motion to dismiss counts 1 through 6 of the third superseding indictment. Now, oh, so there was a superseding indictment. So I apologize. I apologize profusely. I only read you the first indictment. I did not realize there were superseding indictments. However, I will say that you got the gist. You got the gist of the indictment. And I don't want to go and download the other one and read that one. All right. Metaphorist, we should talk about that at some point. Let's read through this opinion. This matter is presently before the court on defendant's motion to dismiss counts 1 through 6 of the third superseding indictment. Footnote 1. The motion is entitled Motion to Dismiss Counts 1, 2, 3, 4, and 5. When this motion was filed, the operative indictment was the second superseding, and counts 1 through 5 thereof charged defendants with committing, conspiring to commit, and aiding and abetting the commission of female genital mutilations in violation of 18 U.S.C. Section 2, 116, and 371. After the motion was filed, the grand jury returned a third superseding indictment, and counts 1 through 6 thereof likewise charged defendants with committing, conspiring to commit, and aiding and abetting the commission of female genital mutilation in violation of 18 U.S.C. 216 and 371. Therefore, the court construes the instant motion as seeking the dismissal of counts 1 through 6 of the third superseding indictment. All right. The government has filed a response in opposition. Defendants have filed a reply, and the court has heard oral argument. For the following reasons, the court shall grant the motion. The case concerns female genital mutilation. There are 8 defendants. The government alleges that Dr. Jumana Nagarwala performed the procedure, that Dr. Fakhruddin Attar allowed Dr. Nagarwala to use his clinic in Livonia, presumably only under his supervision because she is a woman and cannot do anything correctly in his eyes. That was rude, wasn't it? Is that the drinking coming through? I don't know. I wonder if he allowed her to drive to the procedure. In Livonia, Michigan, to perform the procedure, that Farida Attar and Tahira Shafiq assisted Dr. Nagarwala in performing the procedure, and that the other defendants, Farida Arif, Fatima Dahadwala, Hasina Halfal, and Zainab Harianawala. I'm butchering those names, but not as bad as they're butchering those vaginas, who are the mothers of the victims, brought their daughters to the clinic for the procedure. The government alleges that 4 of the victims are residents of Michigan, 3 are residents of Illinois, and 2 are residents of Minnesota. Hessian says, irony aside, it makes me a rage and a sad, and putting it back on. Really missing Vlad Tepes at the moment. All right, there is count 1. Count 1 of the third superseding indictment charges all the defendants with conspiracy to commit female genital mutilation in violation of 18 U.S.C. 371. Counts 2 through 6 charge all of the defendants with committing female genital mutilation and with aiding and abetting each other in doing so in violation of 18 U.S.C. Section 116. And there is a footnote. There's a footnote. Section 116 states, except as provided in subsection B. Oh, we read this already. We read this exact statute, so I'm not going to read it again. Count 7 charges Dr. Nagarwala with conspiracy to travel with intent to engage in illicit sexual conduct in violation of 18 U.S.C. Section 2423B. And count 8 charges 4 of the defendants with conspiracy to obstruct an official proceeding in violation of 18 U.S.C. 1512K. Defendant's motion to dismiss. The plaintiff is the state, Bubba Clem. It looks like there was some investigation that took place. It didn't really say how the investigation started in the affidavit. He investigates crime related to healthcare fraud, prescription drug diversion, public corruption, and international human rights violations. So presumably he was merely investigating this clinic and came upon the possibility that people were engaged in the act of female genital mutilation, although that's not explicitly clear from the complaint. But it is his job. They did not challenge this on grounds for probable cause. They did not, as far as I know, get to the point of challenging the evidence. They dismissed this as unconstitutional. So let's go back to it. Defendant's motion to dismiss. Defendants seek dismissal of all the female genital mutilation charges, substantive conspiracy, and aiding and abetting, on the grounds that Congress lacked authority to enact sections 116A, female genital mutilation statute. Defendants argue that Congress may exercise legislative authority only to the extent allowed by the Constitution, and that the only potentially applicable sources of congressional power, the Necessary and Proper Clause and the Commerce Clause, that is not the only potentially applicable sources of congressional power. There's also the tax and spend power. Do not grant it authority to prohibit female genital mutilation. Section 3, footnote 3, defendants also argue that Section 5 of the 14th Amendment, which states that the Congress shall have the power to enforce by appropriate legislation the provisions of this article, does not empower Congress to prohibit female genital mutilation. Defendants brief at 14 to 20. In its response brief, the government indicates that it does not rely on the 14th Amendment as a basis for upholding the female genital mutilation statute. Rather, the government argues only that Congress has authority to criminalize FGM based on the Necessary and Proper Clause and the Commerce Clause. The government reserves the right to assert other grounds in future cases should the facts and circumstances so merit. And we know from the Obamacare decision that it is not the asserted power that Congress must rely on, but any plausible power. That was a ruling of Chief Justice Roberts that said that, look, even if the Commerce Clause was not proper, but that the tax and spend clause would be proper even though Congress refused to assert it and the president refused to uphold it, that it could be upheld by the Supreme Court through the tax and spend power, even if it was not chosen as the appropriate power for the thing, but if it was plausible that the tax and spend power would work. So the government would reserve those rights. Defendants seek dismissal of all of the... Oh, wait. Sorry. We're back to here. The Necessary and Proper Clause and the Commerce Clause do not grant it authority to prohibit FGM. I would argue that they absolutely have the power to regulate this under the Commerce Clause based on how they regulate everything else. But let's move on and we'll see. I can rant about this later. In response, the government argues that each of these clauses independently provided Congress with the authority to enact the statute. In deciding this motion, the court is aware that it may invalidate a federal statute only upon a plain showing that Congress has exceeded its constitutional bounds, and that the lack of constitutional authority to pass the act in question must be clearly demonstrated. That's Independent Businesses versus Sebelius. That's the Obamacare decision right there that they're going ahead and citing. The Necessary and Proper Clause, Article 1, Section 8, Clause 18 of the Constitution grants Congress the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof. The Necessary and Proper Clause is not an independent grant of power, but it permits Congress to legislate to carry out powers enumerated elsewhere in the Constitution. See U.S. versus Comstock. Noting that whether the Necessary and Proper Clause grants Congress the legislative authority to enact a particular federal statute, we look to see whether the statute contains a means that is rationally related to the implementation of a constitutionally enumerated power. In the present case, the government argues that the relevant enumerated power resides in Article 2, Section 2, Clause 2, which gives the President power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur. Wait, what? Congress may pass legislation to effectuate a treaty, but only to the extent that the two are rationally related. Further, no agreement with a foreign nation can confer power on the Congress or on any other branch of government. Footnote 4. The court notes that two justices expressed their disagreement with this proposition in U.S. v. Bond, Scalia and Thomas, justices concurring, criticizing Holland's statement that if the treaty is valid, there can be no dispute about the validity of the statute under Article 1, Section 8 as a necessary and proper means to execute the powers of the government as unreasonable and citationless. Okay. Further, no agreement with a foreign nation can confer power on the Congress or any other branch of government which is free from the restraints of the Constitution. The treaty on which government relies in the present case is the International Covenant on Civil and Political Rights, ICCPR, which the Senate ratified in 1992. Subsection 5. The first 27 articles of the ICCPR are substantive provisions. Article 28 to 53 deal with reporting and enforcement mechanisms and ratification procedures. The substantive articles cover a wide range of political and civil rights, e.g. the right of self-determination, gender equality, and the right not to be subject to torture, cruel, inhuman, or degrading treatment or punishment, trial and detention rights, prohibition of debtor's prison, freedom of movement, prohibition of ex post facto laws, prohibition of arbitrary or unlawful interference with privacy, family, home, or correspondence, and unlawful attacks on honor and reputation, freedom of conscience and expression, prohibition of war propaganda and hate speech, the right of assembly, freedom of association with others, including the right to form and join trade unions, the right of men and women of marriageable age to marry and to found a family, the right to vote and be elected at genuine periodic elections, equal protection of the law, and the rights of ethnic, religious, and linguistic minorities. Okay. Which the Senate ratified in 1992. And obviously, I disagree with the ratification of this treaty because it contains a hate speech provision. I don't believe that hate speech should be illegal in any circumstances. Specifically, the government points to two provisions of this treaty. Article 3, which calls on the signatories to ensure the equal rights of men and women to the enjoyment of all civil and political rights set forth in the present covenant. And Article 24, which states that every child shall have, without any discrimination as to race, color, sex, language, religion, national or social origin, property, or birth, the right to such measures of protection as are required by his status as a minor on the part of his family, society, and the state. And then that goes to footnote 6, Article 7 of the ICCPR, which prohibits torture and cruel, inhuman, or degrading treatment and punishment, arguably is more closely related to the FGM statute than is either Article 3 or Article 24. However, the government indicates that the U.S. has lodged a reservation to Article 7 and does not rely on this article to make its arguments here. There you go. So the U.S. has reserved its prohibition on torture, cruel, inhumane, or degrading treatment and punishment. Good job. That's the one. That's the one where we made our stand. Okay. The government argues by enacting the female genital mutilation statute that Congress acted reasonably to carry out these two treaty obligations. The court rejects the government's argument for two reasons. First, there's no rational relationship between the female genital mutilation statute and Article 3, which obligates member states to ensure the equal rights of men and women to the enjoyment of all civil and political rights set forth in the present covenant. This article seeks to ensure equal civil and political rights, e.g. the freedom of expression, the right to participate in elections, and protections for defendants in criminal proceedings for men and women. While the FGM statute seeks to protect girls aged 17 and younger from a particular form of physical abuse, there is simply no rational relationship between Article 3 and the FGM statute. Latter does not effectuate the purposes of the former in any way. The relationship between FGM and Article 24 is arguably closer, as noted that article states that every child shall have, without any discrimination as to race, color, sex, language, religion, national or social origin, property, or birth, the right to such measures of protection as are required by his status as a minor on the part of his family, society, and the state. Still, no relationship between female genital mutilation statute and Article 24 is tenuous. Article 24 is an anti-discrimination provision which calls for the protection of minors without regard to their race, color, sex, or other characteristics. As laudable as the prohibition of a particular type of abuse of girls may be, it does not logically further the goal of protecting children on a non-discriminatory basis. Well, I think if we wanted to cut off little boys' clitorises, we'd be equally opposed, right? Second, even assuming the treaty and the FGM statute are rationally related, federalism concerns deprive Congress of the power to enact this statute. Oh, that's rich. In adopting the ICCPR, each member state obliged itself to take the necessary steps in accordance with its constitutional processes to adopt laws or other measures, as may be necessary to give effect to the rights recognized in the present covenant. The constitutional processes in the United States include the important, indeed foundational, division of authority between states and the federal government. This is a terrible argument given the current state of the law. This judge is flat out lying about the reality of how the government does these things all the time. There is absolutely no precedent we can set forth requiring female genital mutilation to only be regulated by the states and not the federal Congress. There is no way you can argue that medical procedures can only be regulated by a state, especially when they are arguably abusive and the person being protected is a minor without the power to consent. This would be a deprivation of any child's rights if it's a deprivation of anyone's rights. This is the conundrum. If we think female genital mutilation is a deprivation of rights, then it is certainly within the purview of the federal Congress under the 14th Amendment. I get that the government isn't making that argument, but under the 14th Amendment, to ensure an equal protection of rights for all of its citizens. And absolutely, if female genital mutilation were to be deemed a violation of a person's human rights, then the government has power. The federal government has power, and we do not need to rely on the states. You can look at any number of healthcare decisions that are federally regulated, and it's quite a few. Your medicine is federally regulated. Your prescription drugs are federally regulated. Your abortion laws are federally regulated and then supplemented by state laws that are allowed to expand, but there's a federal minimum regulation that goes on. All sorts of these things are federally regulated. This judge is lying and making a very bad argument here. Let's see how we go. Sorry, I have to stop and point that out, that this is a very bad argument, that we're gonna suddenly care about federalism on female genital mutilation is the most laughable thing I can imagine a judge saying. We don't care about federalism anywhere except for legitimate family law, like divorces and child custody, and that's about it. And even there, we have a Uniform Custody Jurisdiction Act, Custody Jurisdiction and Enforcement Act, the CCJEA or whatever, that federally regulates the custody and enforcement jurisdiction provisions of family law. This is nonsense. This is offensively bad. Metaphorist, no, circumcision is not federally regulated, but you have to stop conflating male and female circumcision from a legal perspective. Stop for a minute. Stop. Listen. From a legal perspective, we have not determined male circumcision to be damaging in the way we have determined legally female circumcision to be. And they are different procedures. Now, if female and male circumcision were cutting off a fingertip, literally cutting off a fingertip, there would be no difference to the procedure, and it would only be female versus male. There would be only a gender discrimination argument. That would not be a permissible way to look at it legally. When we're talking about cutting off foreskin versus excising a clitoris, potentially sewing together a labia or removing a labia or cauterizing the vaginal area, we're talking about vastly different procedures done. They're not the same thing. So it's not just a gender discrimination argument. Now, were the federal government to determine that male circumcision was equally damaging and thus in need of regulation, which maybe they should, maybe they shouldn't, it doesn't really matter for this argument. If they do that, then it would be federally enforceable, not state enforceable, as a regulated healthcare procedure under the Commerce Clause. It absolutely would be. Absolutely. If they made that determination. They haven't, and you can cry and rail about that all you want. Stop conflating these two issues. They're different procedures, and until they do, it doesn't matter what they've done for male circumcision, because Congress has determined female genital mutilation to be dangerous and damaging to girls, and therefore they have properly regulated under the Commerce Clause. Legally, where we are right now, that is a proper execution of authority. I am happy to argue against it on a principled standpoint if we were similarly treating every other issue as a states' right issue. You don't have states' rights issue. You want a trampled amendment, look at the 10th. States' rights issues have been largely gone since the passage of the 14th. It has effectively superseded the 10th. I'm sorry that that's the case. It just is. So again, stop trying to compare and conflate them. Legally, they are different, and this is a legal argument right now. I've already said we'll have the other argument later. Now, from a legal perspective, this is a bad argument. Let's move on. Division of authority between the states and the federal government, as recognized in the report of the Senate Committee on Foreign Relations, which recommended that the Senate ratify this treaty subject to various reservations, understandings, and declarations. One of those understandings was that the United States understands that this covenant shall be implemented by the federal government to the extent that it exercises legislative and judicial jurisdiction over the matters covered therein. And otherwise by the state and local governments, to the extent that the state and local governments exercise jurisdiction over such matters. Again, to the extent that they don't have jurisdiction here, the federal government absolutely does under all existing law. The federal government shall take measures appropriate to the federal system to the end that the competent authorities of the state or local governments may take appropriated measures for the fulfillment of the convention. Defendants Exhibit S at 23, report of the Senate Committee on Foreign Relations dated March 2nd, 1992. This understanding comported with one recommendation by the Bush administration, which offered the following explanation. In light of Article 50, the provisions of the present covenant shall extend to all parts of the federal states without any limitations or exceptions. It is appropriate to clarify that even though the covenant will apply to state and local authorities, it will be implemented consistent with U.S. concepts of federalism. That's fine. The U.S. concept of federalism is an absolute joke since 1865. And it just really is. I don't know how else to say it. The proposed understanding serves to emphasize domestically that there is no intent to alter the constitutional balance of authority between the state and federal governments or to use the provisions of the covenant to federalize matters now within the competence of the states. Okay. One aspect of this constitutional balance is that the state possesses primary authority for defining and enforcing criminal law. Brecht versus Abrahamson. In the same vein, the Supreme Court has noted that the area of criminal law enforcement, states historically have been sovereign. Yeah, except we have a giant federal criminal code. I mean, other than that. And that the Constitution withholds from the Congress a plenary police power. United States versus Morrison, the court noted that the Constitution's distinction between national and local authority and that the regulation and punishment of intrastate violence has always been the province of the states. Yes, intrastate, within a state. These people traveled to a different state. Further, we can think of no better example of the police power which the founders denied the national government and reposed in the states than the suppression of violent crime and the vindication of its victims. Yeah, we have federal murder charges. We have federal criminal charges for everything you can imagine. Like, again, 6ix9ine is federally charged with conspiracy to commit murder. Like, that's a federal charge. If you take a child across state lines without the consent of the parents, that's a federal kidnapping charge. We have all sorts of federal criminal charges. This is a silly, silly position to take. Keck7Go says, what happened after 1869? The passage of the 14th Amendment, Keck, applied the Bill of Rights to the states, and it ensured a federal enforcement of rights. That has since been the way we have legislated all, everything from civil rights to gay marriage, to gun ownership, to protections of speech. Like if your local cops decided to suppress your speech or religion, that would not have been federally enforceable back in 1855. So it's the passage of the 14th Amendment. Reconstruction redefined what states' rights meant, because let's face it, the Civil War was a stamping out of the states' rights, right? Like the states' rights to criminalize slavery, for example, or to not criminalize slavery, was stamped out by the Civil War, Reconstruction, the passages of the 13th, 14th, and 15th Amendments. And then the 14th Amendment was used later to ensure the voting, to ensure all sorts of the right to go into a public store by a black person, that a store that was labeled whites only, or into a school, any place of public accommodation. Those are all passed under 14th Amendment, or that Civil Rights Act is a 14th Amendment law. Anyway, I'm explaining a lot here, and we're going slow. But yeah, just as a note, state rights do not exist in the way that they did at the founding of this country. For better or worse, there's lots of arguments to be made that we're in a worse state of federalism and constitutionalism than we were before the Civil War. And again, if we were treating everything else the way we treated this under the law, it would be proper, but it's not in the context of how we currently define U.S. law and congressional authority. In Bond versus United States, the Supreme Court commented on the interplay between Congress's authority to implement a treaty and the restraint on that authority imposed by federalism concerns. In that case, defendant was charged with violating the Chemical Weapons Convention Implementation Act, which Congress passed to effectuate the Convention on the Prohibition of the Development, Production, Stockpiling, and Use of Chemical Weapons and their Destruction. The court found it unnecessary to rule on the constitutionality of the statute, as it determined the defendant's use of certain chemicals did not come within the statute's definition of a chemical weapon. Nonetheless, the court's comments on the federalism issue bear repeating. There's no reason to think that sovereign nations that ratified the convention were interested in anything like Bond's common law assault. Even if the treaty does reach that far, nothing prevents Congress from implementing the convention in the same manner it legislates with respect to innumerable other matters, observing the Constitution's division of responsibility between sovereigns and leaving the prosecution of purely local crimes to the states. The convention, after all, is agnostic between enforcement of the state versus federal level. It provided that each state party shall, in accordance with its constitutional processes, adopt the necessary measures to implement its obligations under this convention. Since the creation of the national law, the enforcement of it, and the structure of the administration of the government are all sovereign acts reserved exclusively for state parties. It's not surprising that the convention is so vague on the critical matter of national implementation. Fortunately, we have no need to interpret the scope of the convention in this case. Bond was prosecuted under Section 229. Yeah, they don't have to interpret it. This is a terrible, terrible citation. Because it doesn't support the judge's arguments. And you find this with judges, by the way, that they are bad at citations, and they would, if you cited this, they might yell at you. Okay. I'm not going to read all of the convention stuff. Oh, maybe this one. Characteristically, Justice Scalia's concurring opinion made the argument somewhat more pointedly. Holland places Congress on only one treaty away from acquiring a general police power. The necessary and proper clause cannot bear such weight. As Chief Justice Marshall said regarding it, no great substantive and independent power can be implied as to incidental to other powers or used as a means of executing them. McCulloch versus Maryland. No law that flattens the principle of state sovereignty, whether or not necessary, can be said to be proper. Again, he's taking these arguments and conflating positions. One states that we can't disrupt federalism to implement treaties. That's fine. But then he's taking it with the foregone conclusion that this disrupts federalism and that this is a proper police power of the state and not a proper police power of the federal government, which I don't agree with at all. I don't agree with. The way we have implemented federal police power, this absolutely falls within the purview of the federal government. Application of these principles to the present case leads to the conclusion that Congress overstepped its bounds by legislating to prohibit FGM. Like the common law assault at issue in Bond, FGM is local criminal activity. Oh my goodness. Which, in keeping with long-standing tradition in our federal system of government, is for the states to regulate, not Congress. Therefore, even accepting the government's contention that the criminal punishment of FGM is rationally related to the cited articles of the ICCPR, federalism concerns in the state and the Supreme Court's statements regarding state sovereignty in the area of punishing crime, and the federal government's lack of a general police power prevented Congress from criminalizing FGM. The principle that the Constitution created a federal government of limited powers while reserving a generalized police power to the states is deeply ingrained in our constitutional history, citing Morrison. The FGM statute cannot be sustained under the necessary and proper clause. I would absolutely disagree with that legal assertion. Now let's read his Commerce Clause. Would legalizing female circumcision also legalize penile decapitation, since it's the closest medical procedure? No. However, apparently, according to this judge, it would have to be regulated by the state. So, I don't know. The Commerce Clause. The government also argues that the Commerce Clause empowered Congress to criminalize female genital mutilation. Super Iron Bob, it sure looks like it would make the FBI unconstitutional, doesn't it? Since the FBI is a federal police power, although its investigatory purposes are limited to federal issues. The judge has said that there's no generalized police power at the federal level, so who knows? Government also argues that the Commerce Clause empowered Congress to criminalize FGM. Absolutely, the Commerce Clause does, in the way that we understand the Commerce Clause today. Article 1, Section 8, Clause 3 of the Constitution grants Congress the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. When Congress's authority to legislate under this clause is challenged, the test is whether a rational basis exists for concluding that the activity being regulated substantially affects interstate commerce. That's Gonzalez versus Reich. Review of the case law. And they're going to bring up my favorite case in all of Commerce Clause jurisprudence. Many cases have analyzed the issue of congressional power and its limits under the Commerce Clause. Of the many such cases cited by the parties in chronological order, the court finds that those that follow to be the most instructive. Wickard versus Filburn. Listen to this. This guy is going to argue that the regulation of wheat is more in line with the Commerce Clause than the regulation of a health service across state lines. An Ohio farmer grew more wheat than was permitted under the Agricultural Adjustment Act. The purpose of the statute as related to wheat is to control the volume moving in interstate and foreign commerce in order to avoid surpluses and shortages and the consequent abnormally low or high wheat prices and obstructions to commerce. Filburn was permitted to grow wheat on 11.1 acres, but did so on 23 acres. He was fined for the 239 bushels he harvested on the excess acreage. Instead of paying, Filburn brought suit to enjoin the enforcement of this fine, arguing that the statute was unconstitutional because it reached not only wheat that was sold on the open market, but also wheat intended wholly for consumption on the farm, which he contended had at most an indirect effect on interstate commerce. Importantly, Wickard versus Filburn, he only was intending to sell the wheat grown on the 11.1 acres, and the remaining acres he was leaving. It was specifically remaining in the state. It was specifically not entering the stream of commerce. This is him growing wheat for his own use. His own use. The Supreme Court rejected this argument because even if Filburn consumed the excess wheat himself, e.g. for making flour or feeding his livestock or planting the next crop, his doing so affected the overall wheat market, and this undermined Congress's efforts to stabilize prices and supply, as those efforts depended on accurate predictions about the total wheat production and consumption each year. That Filburn's own contribution to the demand for wheat may be trivial by itself is not enough to remove him from the scope of federal regulation, whereas here his contribution, taken together with that of many others similarly situated, is far from trivial. That is, even if Filburn's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. Now you tell me that Congress cannot regulate a medical procedure that it does not want to occur under the Commerce Clause. And you tell me that someone performing that procedure within a particular state does not have an impact on foreign commerce. Congress does this under the Controlled Substances Act. Everywhere. Can you buy federally? Is it federally legal to buy marijuana in any state? No. No. And if the feds want to arrest you for buying weed in Colorado, they can, and they'll win, and you'll lose. Period. It's a federal felony, still under the Controlled Substances Act. Why? Because Congress has the power to regulate controlled substances under the Controlled Substances Act. And even those that are produced within Colorado will only enter the marketplace within Colorado, or only purchased and consumed in Colorado, affect interstate commerce because they won't be purchased and consumed from a different state. Period. That is how we've interpreted the Commerce Clause. To state that they can't do this for female circumcision is nonsensical under our current understanding of the Commerce Clause. John Russell, it's really stretching it. Absolutely. However, it's done in a clinic by a doctor under surgical procedures. Anesthetic is given. It's done with nurses attending. What else do you call it? What else do you call it? I mean, I know it's a barbaric procedure, but it's in America, it's done by a licensed physician. In Perez versus United States, defendant was convicted of loan sharking under the Consumer Credit Protection Act. He challenged the statute on Commerce Clause grounds, arguing that all that is involved in loan sharking is traditionally local activity. The Supreme Court rejected this argument because where the class of activities is regulated, and that class is within the reach of federal power, the courts have no power to exercise as trivial individual instances of the class. Further, extortionate credit transactions, though purely intrastate, may, in the judgment of Congress, affect interstate commerce. The court noted the extensive congressional findings showing the tie-in between local loan sharks and interstate crimes. So again, loan sharking that occurs entirely within a state and does not have anything to do with parties crossing state lines or money crossing state lines is still a federally regulated activity. Congress found that loan sharking is the second largest source of revenue for organized crime. That organized crime takes over $350 million a year from America's poor through loan sharking alone, and that such money serves as a source of funds to bookmakers, narcotics dealers, and other racketeers. Court reasoned that based on these findings, Congress could regulate local loan sharking because it is part of the organized interstate crime. In United States versus Lopez, defendant brought a gun to his high school. He was convicted of possessing a firearm at a school in violation of the Gun-Free School Zones Act. The Supreme Court vacated the conviction because Congress lacked authority under the Commerce Clause to enact the statute. The court began by identifying three broad categories of activity that Congress may regulate under its commerce power. First, Congress may regulate the use of the channels of interstate commerce. Second, Congress is empowered to regulate and protect the instrumentalities of interstate commerce or persons or things that in interstate commerce, even though the threat may come from intrastate activities. Finally, Congress's commerce authority includes the power to regulate those activities having a substantial relation to interstate commerce, i.e. those activities that substantially affect interstate commerce. So now they're going to talk about a legally purchased gun being drawn in a school parking lot that the federal Congress did not have the ability to outlaw that. Again, that is beyond the it's beyond commerce at that point. The purchase was already legal. The commerce already occurred. Brandishing a weapon in a parking lot of a school or possessing a weapon in a parking lot at a school has nothing to do with commerce. Undergoing a medical procedure in a clinic by a doctor has everything to do with commerce. Court noted that only the third category applied in that case. The parties in the present case likewise agree that only the third category applies. Okay, so the third category, is finally Congress's commerce authority includes the power to regulate those activities having a substantial relation to interstate commerce. Those activities that substantially affect interstate commerce. Having a medical procedure that you pay for, performed by a licensed physician that is licensed by a state, is interstate commerce. In every instance, try and tell me it isn't in any other category. This is a ludicrous decision. Court noted that only the third category applied in that case. Parties in the present case likewise agree only the third category applies. As this category, the proper test requires an analysis of whether the regulated activity substantially affects interstate commerce. Where economic activity substantially affects interstate commerce, legislation regulating the activity will be sustained. The court found no merit in the government's explanation as to how possession of a gun at school substantially affects interstate commerce. Because it doesn't. Possession of a gun that was already purchased and sold, bought and sold, doesn't affect interstate commerce later. Mere possession is not commerce. I'm not going to read through that citation to the court because it was long. Additionally, the court noted that the statute by its terms has nothing to do with commerce or any sort of economic enterprise. The statute contains no jurisdictional element which would ensure, though through case-by-case inquiry, that the firearm possession in question affects interstate commerce, and that it is the states, not the federal government, that have primary authority for defining and enforcing the law. In U.S. v. Morrison, plaintiff alleged that the two defendants raped her when the three were students at Virginia Polytechnic Institute. She sued them under the Violence Against Women Act, which created a private right of action for victims of crimes of violence motivated by gender. The district court dismissed the complaint on the grounds that Congress lacked authority under the Commerce Clause or the 14th Amendment to enact this statute. Again, are you paying for rapes? Are rapes bought and sold? The Fourth Circuit affirmed. In affirming the Fourth Circuit, the Supreme Court began by noting the importance of the fact that the Violence Against Women Act did not regulate economic activity. Gender-motivated crimes of violence are not, in any sense of the phrase, economic activity. While we need not adopt a categorical rule against aggregating the effects of any non-economic activity in order to decide these cases, thus far in our nation's history, our cases have upheld Commerce Clause regulation of intrastate activity only where that activity is economic in nature. Right. Raping someone is, unless you're going to a rape service, is not commerce. However, female circumcision performed by a doctor in a clinic with nurses attending is absolutely economic activity. This is the dumbest argument. I can't believe a judge is making this seriously. As in Lopez, the court rejected the government's explanations as to how violent crime may affect interstate commerce. Court quotes this passage at length because the reasoning applies equally to the present case. Let's see. Let's see. In contrast with the lack of congressional findings that we faced in Lopez, the Violence Against Women Act is supported by numerous findings regarding the serious impact that gender-motivated violence has on victims and their families, but the existence of congressional findings is not sufficient by itself to sustain the constitutionality of Commerce Clause legislation. In these cases, Congress's findings are substantially weakened by the fact they rely so heavily on a method of reasoning that we have already rejected as unworkable if we are to maintain the Constitution's enumeration of powers. Congress found that gender-motivated violence affects interstate commerce, quote, by deterring potential victims from traveling interstate, from engaging in employment in interstate business, and from transacting with businesses and in places involved in interstate commerce, by diminishing national productivity, increasing medical and other costs, and decreasing the supply of and the demand for interstate products. Given these findings and petitioners' arguments, the concern we expressed in Lopez that Congress might use the Commerce Clause to completely obliterate the constitutional distinction between national and local authority seems well-founded. The reasoning that petitioners advance seeks to follow the but-for causal chain from the initial occurrence of violent crime, suppression of which has always been the prime objective of the state's police power, to every attenuated effect upon interstate commerce. If accepted, petitioners' reasoning would allow Congress to regulate any crime as long as the nationwide aggregated impact of that crime has substantial effects on employment, production, transit, or consumption. This is a good ruling. Lopez is a good ruling, by the way. Indeed, if Congress may regulate gender-motivated violence, it would be able to regulate murder or any other type of violence, since gender-motivated violence, as a subset of all violent crime, is certain to have lesser economic impacts than the larger class of which it is a part. We accordingly reject the argument that Congress may regulate non-economic violent criminal conduct based solely on that conduct's aggregate effect on interstate commerce. The Constitution requires a distinction between what is truly national and what is truly local. In recognizing this fact, we preserve one of the few principles that has been consistent since the clause was adopted: the regulation and punishment of intrastate violence that is not directed at the instrumentalities, channels, or goods involved in interstate commerce has always been the province of the states. Indeed, we can think of no better example of the police power which the founders denied the national government and reposed in the states than the suppression of violent crime and the vindication of its victims. This isn't violent crime. This isn't violent crime. This is a medical act. It's a procedure. I don't know what to do. This reasoning is so stupid I can't even frickin' take it. Okay, hold on. Okay, CAC 7 go. I need a brief break before I eat this microphone in rage. What would it legislatively require for minimum punishment for not returning shopping trolleys to their rightful place be death? And if you try and push them to the return spot in the parking lot, be double death? How do we decide the right punishment for the crime? Keck, I don't know. I guess you'd have to be, let me be controversial, if I may. You have to be a young black man, and the person enforcing the crime has to be a cop, preferably a white cop who hates black people. That's how. Then it's a death sentence for everybody. Also, the black guy has weed. Just kidding, y'all. Just kidding. Just kidding. No, Clay, early medical acts can be violent. I'm pointing out that the categorization of violent crime is one that is distinctly non-commercial, whereas a medical procedure is distinctly commercial. It happens under the Commerce Clause. Think of, like, even if they didn't pay for it, right? Let's say Nagarwala came in and decided to just perform these for free out of the goodness of her heart. The clinic has 2 nurses who assisted with the procedures. Presumably, there was a scalpel involved. There was anesthetic. There was a needle used. Those needles are disposed of. All of these items are purchased and used in intrastate and interstate commerce. All of them are used for medical procedures. So even if they perform the procedures free of charge, the mere presence inside a medical facility has an imputed cost to it, because for you or I to get into an examining room of a clinic would cost hundreds of dollars per hour, right? And to have a doctor and 2 nurses in attendance would cost even more, even if your medical procedure is very basic. Think about how much it costs to have a blood test in the United States. Now snip off a part of your body and have it overseen by a surgeon, and think how much that costs. Even if you don't charge, there's a severe commercial implication. That's what I'm talking about. Miles Jenkins, this can absolutely be overturned, and I really, really hope, that the federal government appeals this one personally, because we need a Supreme Court decision on this. We really do. If the Supreme Court's going to obliterate the Commerce Clause, that could be a good thing. I could actually support that. But that means they've got to start rolling back a ton of laws. Like, this would change how we view a bunch of things. Okay, anyway, let's get through this. The court pauses here to note an interesting point defendants make at pages 12 and 13 of this reply brief. Supreme Court's decision in Morrison, which postdated ratification of the ICCPR by 8 years, did not mention that treaty as a possible basis for upholding the Violence Against Women Act, although this argument was raised in a lengthy amicus brief that was filed with the Supreme Court by a group of international legal scholars and human rights experts. Okay, great. Who cares? In Norton versus Ashcroft, plaintiffs were 2 anti-abortion protesters who protested outside a Planned Parenthood clinic. They were threatened with arrest under the Freedom of Access to Clinic Entrances Act, which prohibits the obstruction or intimidation of those seeking or providing reproductive health services. Plaintiffs brought suit to challenge the constitutionality of the statute, including on Commerce Clause grounds. In rejecting this challenge, the Sixth Circuit began by interpreting Morrison as identifying 4 relevant considerations: the economic nature of the activity, a jurisdictional element limiting the reach of the law to a discrete set of activities that has an explicit connection with or effect on interstate commerce, express congressional findings regarding the regulated activities' effect on interstate commerce, and the link between the regulated activity and interstate commerce. Regarding the first factor, the Sixth Circuit Court found that the regulated activity, blocking access to abortion clinics, is commercial in nature because of its direct economic effect, causing clinics to close, delaying services, persuading some doctors not to provide services. Guys, a federal judge is unironically saying that someone stopping someone from entering a clinic is more commercial activity than someone entering a clinic and buying a female clitoral snipping. Think about how stupid you have to be this judge and argue this. Think about how ridiculous this judge's argument is when he says that someone standing outside saying, "Hey, don't abort your baby," is commercial activity, but someone going in and handing some disgusting doctor a couple $100 to snip the skin off of their child's vagina is not commercial activity. Think about how... And for what purpose? What are you protecting? The Muslims don't like you, Friedman. They would pay to throw you off a building. All right. Regarding the second factor, the Sixth Circuit noted that the statute lacked a formal jurisdictional element, but it found this to be unimportant. In light of the extensive congressional findings regarding the economically disruptive effects of clinic blockades and anti-abortion violence, think about that too. Like the absurdly small rates of actual anti-abortion violence are comical. With that, like it's not, anti-abortion violence is not comical. I'm saying the fact that anti-abortion violence, which is a pretty limited field of violence with pretty minimal instances of actual occurrences, is said to be having a significant enough effect on interstate commerce to override one of the factors of the tests by itself. Like, that's crazy. It's crazy how far that reaches. Okay, let's see. These findings, which are the third factor, were contained in extensive reports made by both Senate and House committees and also covered the fourth factor, the link between the activity and interstate commerce. For example, Congress found that there's a national commercial market for abortion services, that anti-abortion protests burden interstate commerce. I'm betting there's a national commercial market for a particular community to shove scissors in their children's vaginas and chop off parts of them. That patients and physicians often travel interstate. These patients traveled interstate, you dumb pile of trash, to obtain or provide abortion services, and that protests sometimes cause clinics to close and for some doctors to stop working in this field. The Sixth Circuit concluded, I'm not going to read the Sixth Circuit's decision, that there's nothing else to read. This case alone shows that this should be regulated by Congress. In Gonzalez versus Reich, plaintiffs were California residents who used marijuana for medical reasons, as allowed by that state's Compassionate Use Act. One of the plaintiffs grew her own marijuana plants, while the other received her marijuana free of charge from two caregivers. After the DEA confiscated plaintiffs' marijuana, plaintiffs sought an injunction prohibiting the United States from enforcing the Controlled Substances Act to the extent it prevents them from possessing, obtaining, or manufacturing cannabis for their personal medical use. The district court denied the injunction, but the Ninth Circuit reversed, finding that Congress could not regulate the intrastate non-commercial cultivation and possession of cannabis for personal medical purposes. The Supreme Court reversed. As in Lopez and Morrison, the court began by noting that only the third category of Commerce Clause regulation was at issue, i.e. the power to regulate activities that substantially affect interstate commerce. The court then rejected plaintiffs' arguments, finding that striking similarities with Wickard. I'm not going to read this citation again. These start to take a long time. But basically, they found that even though growing marijuana is an unlawful market, that if the people grew their own marijuana for their own use in California, that they wouldn't be buying from the black market. The black market also gets shot by police. The court rejected plaintiffs' arguments that the statute could not be applied to them because Congress had not made any findings that their interstate cultivation and possession of marijuana affected interstate commerce. We need not determine whether respondents' activities taken in the aggregate substantially affect interstate commerce in fact, but only whether a rational basis exists for so concluding. The court noted that Congress did make findings regarding the effects of intrastate drug activity on interstate commerce. Further, given the enforcement difficulties that attend distinguishing between marijuana cultivated locally and marijuana grown elsewhere and concerns about diversion into illicit channels, we have no difficulty concluding that Congress had a rational basis for believing that failure to regulate the intrastate manufacture and possession of marijuana would leave a gaping hole in the Controlled Substances Act. Now, if only they could find a member of a certain community to come stitch up part of that hole so it wasn't so pleasurable when something came and shoved itself inside of it. The court went on to distinguish Lopez and Morrison. I'm not going to read that. In United States versus Chambers, defendant was convicted of possessing child pornography. Polaroid photos he had taken himself and kept at home. Well, just gas him. On appeal, he argued that the statute was unconstitutional as it applied to him because his homegrown pornography had no effect on interstate commerce. The Sixth Circuit rejected this argument based on rage, reasoning that both marijuana and child pornography are fungible commodities for which there is an interstate market. So again, taking pictures of little children, nude pictures of them for your beat-off material, is that taking them solely of children within the state and keeping all those pictures to yourself on Polaroid so it didn't touch a computer. Because if it goes in your computer, guys, it's in interstate commerce. But taking those pictures in your state with a camera purchased in your state, children in your state, and the Polaroid prints never leaving your state, that affects interstate commerce. But traveling from Minnesota to Detroit to have a doctor come in and perform a medical procedure, that doesn't have anything to do with interstate commerce. What are you talking about? Finally, in Taylor versus United States, defendant was convicted under the Hobbs Act of robbing 2 marijuana dealers in Virginia. That statute makes it a crime for a person to affect commerce or to attempt to do so by robbery. In an effort to overturn his conviction, defendant argued that the government had not proven any effect on interstate commerce. The court noted that the Commerce Clause permits Congress to regulate 3 categories of activity, and as in other cases discussed above, it focused on the third category, those with a substantial effect on interstate commerce. The court then reiterated the following statement from Morrison. While this final category is broad, thus far in our nation's history, our cases have upheld Commerce Clause regulation of intrastate activity only where that activity is economic in nature. The court went on to say that the activity at issue, the sale of marijuana, is unquestionably an economic activity, and it upheld the statute and defendant's conviction because blah, 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 blah. Let's hear his reasoning, because I'm sure it's absolutely brilliant, as befitting a federal judge. Federal judges, guys, they are the smartest people around. They know everything. Must I take a drink? Yes, I must. In deciding whether Congress has used its legislative power permissibly under the Commerce Clause, the cases instruct to first evaluate the economic nature of the regulated activity. In the present case, the government has failed to show that female genital mutilation is a commercial activity. It claims that, like child pornography and marijuana, an interstate market exists for female genital mutilation. That's the government's brief at 32. Yet the government's only evidence of such a market is the fact that it has alleged 9 female genital mutilation victims in the present cases, 5 of whom were brought to Michigan from neighboring states. This is not a market, but a small number of alleged victims. Because, guys, it only happened 9 times ever. Didn't you know that? Female genital mutilation has only occurred 9 times in the history of the entire earth. Because don't forget, Congress regulates both interstate and foreign commerce. So female genital mutilation, it's only occurred 9 times. If there is an interstate market for female genital mutilation, why is this the first time the government has ever brought charges under this 1996 statute? What kind of reasoning is that? What kind of reasoning is that? The government indicates that there was one other female genital mutilation prosecution in 2005 in which the 2 defendants allegedly offered to perform FGM on 2 minor girls for $8,000. However, this offer was to an undercover agent, not parents seeking this service, and the defendants pled guilty to child pornography charges. The government's only other argument for a commercial aspect of FGM is Senator Wellstone's comment in 1995 that the FGM statute would deter medical professionals, some of whom reportedly have been offered as much as $3,000 to perform mutilations on young girls. The government has offered no evidence of money changing hands for such mutilations. Can you imagine? Can you imagine, honestly, the government making the argument after passing a statute making murder illegal, of saying, well, why is this the first one? How do we know that other murders have ever occurred? I don't know. How, like, okay. The government's attempt to show that there's an interstate market for female genital mutilation falls flat. Its comparison to the multi-billion-dollar interstate markets for marijuana and pornography is unsupported and unconvincing. Let's just be clear here. The size of the market doesn't actually matter for interstate commerce, you dumb piece of trash, judge. And you know it. You liar. The government also contends that FGM is an illegal form of health care, and since Congress can regulate health care, it can regulate FGM. In an effort to show that FGM is a form of health care, the government points to the fact that two of the defendants are physicians, that the procedure was performed at a medical clinic, and that Dr. Nagarwala used commercially sold medical tools and supplies, including Valium, a Schedule 6 controlled substance, federally regulated as a commercial product. The comparison of FGM to health care is unsuitable. FGM is a form of physical assault, not anything approaching a healthcare service. Wait, what? The cases the government cites in this section of its brief deal with abortion services and healthcare generally, which bear no resemblance to the crime of mutilating girls' genitalia. You're sitting here saying it's not a crime. You're saying it's not a crime, you dumb idiot. The government further asserts that, like the legislation at issue in Reich, Congress has enacted a comprehensive regulatory regime to eradicate FGM. The regulatory regime at issue in Reich is the Comprehensive Drug Abuse Prevention and Control Act and implementing regulations. This statute covers drug treatment, Title I, drug control and enforcement, Title II, and drug importation, Title III. Title II, which classifies a long list of drugs in one of 5 schedules, sets strict requirements regarding registration, labeling and packaging, production quotas, drug security, and record keeping. There's no comparable regulatory regime for FGM. I guess if we set up a regulatory scheme where all female genital mutilated children had to be labeled appropriately, that would be fine, you disgusting man. But simply a ban on the practice. In Reich, the Supreme Court noted that economics refers to the production, distribution, consumption of commodities, and found that the CIA regulates the production, distribution, consumption of commodities for which there is an established and lucrative interstate market. No such comparison can be made with FGM. FGM can, again, guys, try and create a brand new form of heroin that's never been sold before, like a brand new derivative of opiate. Okay? Create a brand new one. Never been sold before, ever. And distribute it and see how far that gets you. And then make the same argument. That's fine. It's good. FGM cannot, by any stretch of the imagination, be classified as economic or commercial activity. Oh, it's not much of a stretch of the imagination. There is no suggestion that the procedure is done for money. Aside from the unsupported comment made years ago by Senator Wellstone, it doesn't matter if it's free, you other F word. Nor is there any suggestion that this service is offered within anything approaching an established interstate market as exists for illegal drugs and pornography. Again, the fact that it's done by a doctor in a clinic under clinical conditions is less established than the black market for child pornography and weed. The fact that they had to call a specific doctor in the community to perform a specific service that's specifically outlawed, that is less established to this judge than weed and child porn. This is nonsense. Committing FGM is comparable to possessing a gun at school. Guys, if you've ever possessed a gun at a school, that's the same thing as chopping the vagina off of a little girl. A criminal act that has nothing to do with commerce of any sort of economic enterprise. This judge should be impeached. Nor can the court distinguish FGM from gender-motivated crimes of violence, which the Supreme Court noted in Morrison are not in any sense of the phrase economic activity. Even assuming that FGM is a widespread practice within the United States, a fact the government has not established, it cannot be as widespread as violence against women. Violence against women is not an economic activity. A service you pay for in a medical facility is, you dummy. If, as the Supreme Court found in Morrison, rape and other forms of sexual assault against women are not economic or commercial activity and therefore not part of interstate market, no different conclusion can be reached concerning FGM, which is another form of gender-related violence, except one that's paid for and done with the consent of the parents. Like, again, if there was a rape shack where you paid to have your 7-year-old raped by a doctor, that would be commercial activity that could be regulated. It's called prostitution. Child prostitution is regulated by the federal government, you dummy. The second factor the court must consider is whether the statute contains a jurisdictional element limiting the reach of the law to a discrete set of activities that has an explicit connection with their effect on interstate commerce. There's no jurisdictional element in the FGM statute which does not require any proof that the victims or the provider traveled in or had any effect on interstate commerce. Again, regulation of wheat entirely within a state did have an effect on interstate commerce. That requirement is so minimal that it's sad. The case, guys, this will be overturned. This should be overturned immediately. Like, this is a terrible, terrible decision. The case indicates that the absence of jurisdictional element is unimportant if there are sufficient congressional findings or other evidence of a substantial effect on interstate commerce. In the present case, however, there are no congressional findings other than a pro forma ones that accompanied passage of the statute. Let's read them. The Congress finds that the practice of female genital mutilation is carried out by members of certain cultural and religious groups within the United States. Practice often results in the occurrence of physical and psychological health effects that harm the women involved. Such mutilation infringes upon the guaranteed rights secured by federal and state law, both statutory and constitutional. The unique circumstances surrounding the practices of FGM place it beyond the ability of a single state or local jurisdiction to control. The practice of FGM can be prohibited without abridging the exercise of any rights guaranteed under the First Amendment of the Constitution or under any other law, and Congress has the affirmative power under Section 8, Article 1, and the Necessary and Proper Clause, Section 5 of the 14th Amendment, as well as the Treaty Clause to the Constitution to enact such legislation. Those are the congressional findings. However, these are not findings as much as unsupported conclusions. That's all congressional findings are biased supported conclusions, by the way. Because congressional findings, reminder, have found that marijuana is inherently dangerous. Remember that. Remember that congressional findings have found that marijuana is inherently dangerous in need of regulation to a greater degree than alcohol and cigarettes. So when you want the validity of congressional findings, there you go. And they do not begin to compare with the extensive findings made, for example, by both houses of Congress in Norton, Reich, and Perez. Nor are these types of detailed record-based findings that would enable us to evaluate the legislative judgment that the activity in question substantially affected interstate commerce, even though no such substantial effect was visible to the naked eye. Oh, it's visible to the naked eye. Hessian the entire thing. Lydia Schewitz. Whoops. This is a tough topic that I appreciate you're going over in a way that is methodical and easy to understand. I hope you're having a pleasant holiday and that you are happy. I am always happy. I am always happy, even when I'm angry. The court next comes to the fourth factor, the link between the regulated activity and interstate commerce, whether there's a rational basis for finding that female genital mutilation has a substantial effect on interstate commerce. Here the government's argument amounts to this. There's a market for FGM, and even if defendants' activities have only a slight effect on that market, Congress can regulate it just as in Wickard, Reich, and Chambers. Yes, just as in all of the upheld Commerce Clause cases, that even if the effect is insignificant, Congress can regulate it. Only all of the cases, though. That is, the government seems to concede that it cannot show the defendants by performing FGM and or aiding and abetting it or conspiring to do so had a substantial effect on interstate commerce. They don't have to. But the argument continues because Congress can regulate the market for this service, it can also regulate defendants' activities in that market, regardless of how trivial their impact individually may be on the market as a whole. It goes on to state that because that's what every single one of those court cases states. For the reasons stated above, the court rejects this argument. There is no evidence that FGM is a commercial activity, and there's no evidence that anyone beyond the mothers of the 9 girls alleged in this third superseding indictment is in the market for this service. I'm sure no one else in a particular community is in the market for FGM. Finally, the government asserts that only a federal statute can deal with FGM because, as Congress asserted in its fourth finding, the unique circumstances surrounding the practice of female genital mutilation place it beyond the ability of a single state or local jurisdiction to control. See Supra Note 8. This argument fails for at least 2 reasons. First, the Commerce Clause allows Congress to regulate commercial activity that has a substantial effect on interstate commerce, not activity that is beyond the ability of a single state or local jurisdiction to control. That's just a different way of saying that it has a substantial effect. Second, the government informs the court that 27 states have passed FGM statutes, and nothing prevents the others from doing so. Further, counsel for the government argued during the December 5th, 2017 hearing on defendant's motion to dismiss one of the counts of the second superseding indictment that FGM is criminal sexual conduct because it involves unlawful touching and penetration. That is correct, and FGM could already be prosecuted in every state under every existing criminal sexual conduct statutes. No, no, no. No, you liar. You know that's a lie, and I hate you for it. To say nothing of battery or child abuse statutes, the government's suggestion that those seeking the procedure can travel to refuge states where the practice is not prohibited is simply false. No, they're literally doing it. They're traveling to Detroit to do it, you dummy. Because Michigan's laws are not comprehensive enough to cover a medical touch to a genital area of a child with the parent's consent. You disgusting, lying coward of a judge. Were you afraid that your husband would wife burn you for this? Is that what you were afraid of? What is wrong with you? Conclusion, having reviewed Section 116A with the greatest possible deference to the Muslims, not to the state, the court concludes that it is unconstitutional. Congress had no authority to pass a statute under either the Necessary and Proper Clause or the Commerce Clause. Wrong on both accounts, you idiot. The Necessary and Proper Clause does not permit Congress to pass legislation to enforce treaty obligations, but there must be a rational relationship between the two. In the present case, there is no such relationship between the ICCPR and the FGM statute. Article 3 calls for the equal rights of men and women to the enjoyment, blah, 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 while Article 4 calls for protection of children without discrimination based on race, color, sex, language, religion, national or social origin, property, or birth. Neither article is rationally related to the FGM statute, which prohibits mutilation of girls' genitalia. Even if it could be argued that the statute rationally seeks to implement a provision of the ICCPR, Congress may not enact such a statute because the Supreme Court has stated the federal government has no plenary police power. God, you're such... Oh, it's such a bad argument. This would get like a D- in law school. And the clearest example of traditional state authority is the punishment of local criminal activity. Federalism concerns demand that the division of authority between federal and state governments be respected. No treaty and no statute enacted to implement a treaty may upset this balance, nor was enactment of the FGM statute a permissible exercise of congressional power under the Commerce Clause. That clause permits Congress to regulate activity that is commercial or economic in nature and that substantially affects interstate commerce either directly or as part of an interstate market that has such an effect. The government has not shown that either prong is met. There is nothing commercial or economic about female genital mutilation. As despicable as the practice may be, it is essentially a criminal assault, just like the rape at issue in Morrison. Sure, just the same thing. Just the same thing. See, in Morrison, what happened is the woman got in a car. Actually, the woman's mother put her in a car. She was only 7 years old at the time, and she drove her to a different state where two men came and raped her, and then she paid the men for that rape. That's how it's just like the rape at issue in Morrison, because that's the only thing that would make them even close to comparable. Let's see. Nor has the government shown that female genital mutilation itself has any effect on interstate commerce or that a market exists for female genital mutilation beyond the mothers of the 9 victims alleged in the third superseding indictment. There is, in short, no rational basis to conclude that FGM has any effect, to say nothing of a substantial effect on interstate commerce. A rational basis test is the lowest possible bar. You can pass anything under a rational basis test. This guy is ridiculous. The present case cannot be distinguished from Lopez or Morrison. I mean, it can, as in those cases, FGM is a crime that could be prosecuted under state law. No, it's not. It's not a crime, though, unless the federal law makes it a crime. By the way, to dispel one other part of his argument, the Controlled Substances Act, right, which prohibits various drugs from being manufactured or distributed or possessed, there are similar statutes to the Controlled Substances Act in all 50 states. So him saying that 27 states have passed female genital mutilation prohibitions does not mean that the federal government cannot also pass a female genital mutilation provision. Absolutely does not. It's a nonsensical point. I don't know why he even made it. Murder is illegal under federal law. Murder is also illegal in all 50 states. Last I checked, and they all have individual statutes making it illegal. So to say that the federal law and it has to be like non-existent if state laws exist is nonsensical. Actually, the federal law would supersede when the federal provisions are met. FGM is not part of a larger market, and it has no demonstrated effect on interstate commerce. Again, why didn't they do it in Minnesota, you dumb pile of... Why didn't they just do it in Minnesota? Why'd they travel to Detroit? The Commerce Clause does not permit Congress to regulate a crime of this nature. Carrie Dalton, I fully agree with you. What angers Carrie most about the decision is that when it's convenient to his argument that it's a medical procedure, it is. And when it's convenient to his argument, it's a violent act instead of a medical procedure. Yeah, absolutely. As the Supreme Court has stated, a criminal act committed wholly within a state cannot be made an offense against the United States unless it is some relation to the execution of a power of Congress or to some matter within the jurisdiction of the United States. For the reasons stated above, the court concludes that Congress had no authority to enact 18 U.S.C. 116A under either grant of power which the government relies. Therefore, the statute is unconstitutional. Accordingly, it is ordered the defendant's motion to dismiss counts 1 through 6 of the third superseding indictment is granted. Signed, Bernard Friedman, Senior United States District Judge of Detroit. And Bernard should be removed from office. And he should be sent on a one-way ticket to Greenland, where he can live out the rest of his days and die peacefully of natural causes. natural causes like jumping off a building or whatever. Well, there you have it, guys. There you have it. I don't have much to say other than that. It's almost 3 in the morning here. We've been going just short of 3 hours. I thank you very much for joining me through one crazy count of Tekashi 6ix9ine. If you want more 6ix9ine content, if you want me to follow the case, please let me know in the comments. I'm happy to bring on a 6ix9ine expert by the name of Maxwell Kimball to help me through. We can look at the state crimes that 6ix9ine is charged with as well, and we can talk about him from a musician's perspective. I'm happy to do that. If that's something you guys want to see, please let me know in the comments. I will keep my eye out for the appeal of this case. I mean, the government doesn't have to appeal it, but God, I hope they do. I hope they do. We cannot allow this selective reading of the Commerce Clause. Like, again, if I can't express how broad the Commerce Clause power is, and that's fine, that's a bad thing, and we can want to remove that power from Congress, but this ruling won't do that. It'll be this weird blip on the graph where we let Congress regulate everything, and this one thing is just way outside of it, and that one thing just happens to be female genital mutilation. Why on earth are we making the stand there? It's crazy. Metaphora says, let's go through the Washington mutual combat law soon. I'll have to look it up. All right, guys. Here's the deal. Tomorrow, today, whatever it is, later today is Thanksgiving. I wish you all a happy Thanksgiving. Spend it with people who make you happy, doing things that make you happy. That's what it's for. Give thanks to the blessings that you have. Give thanks if you live in a first world country and have the ability to provide for yourself and your loved ones. Give thanks for that. You don't have to thank God. Give thanks to the systems of capitalism that have brought us to this, to the principles of freedom that have brought us to this. Give thanks to those around you who have helped you get to a place of sustainability. If you're not starving in a street, if you've got an internet connection, thank someone for it. And do spend time with people who make you enjoy life and enjoy that time spent. Don't get wrapped up in political arguments. Don't argue about the virtues and vices of male and female circumcision around the Thanksgiving table. Take your time and spend it having peaceful and fun conversations. If I can just pontificate for a tiny moment, don't get wrapped up on defending Trump. Don't get wrapped up on blaming Trump. Don't get wrapped up on that stuff, guys. Not tomorrow, not today. Today is a time to be at peace with people, and no one wants the guy at the table arguing politics when everyone else is catching up on what the family's been up to. It's not the time for it. Enjoy those people around you and don't push them away. If I can say that one thing and have that stick, my job today will be done. I will attempt to do a stream tomorrow. I'll pick the topic as soon as I can. I'm not entirely sure what I'm going to do yet, but there are a lot of good topics out there. So I will try and find something to do. If you have nothing else to do tomorrow night, when all the turkey is sitting in your stomach and you can barely stay awake, come join me, and I'll help you go to sleep with some weird ASMR reading. And then that's it, guys. Thanks so much for watching. Thanks so much for hanging out with me tonight, and we'll talk to you very soon. The last super chat of the night is from Gojirify. He says, "Smooth jazz Rekieta." Yeah, it's a weird thing. But it's kind of fun. Starting Monday of next week, we'll be full bore, full-throated screaming or whatever it takes. Normal volume Rekieta. So I'll see you all then. Thanks, guys. You guys have a good night. I'm going to blank out the screen, and we'll talk to you tomorrow. Peace.